Personal, my lord, we shall put him on notice.
Put him on notice, yes. Leave to
Obliged.
file. Let's call the list.
Obliged.
Number one.
You mentioned like that. Yes, Mr. Mukherjee, where is Mr. Milal Kalti Ghosh? Inform me.
This is the matter your lordship kept today. Unfortunately, my lord, today, my lord, we have to go for the cremation.
Yes.
Mr. Shen,
Uh,
last question. Well,
Mr. Sen,
kindly,
you can file it physically. I'm giving you leave to file physically. Or you want to do it tomorrow? Because I will be.
no, if
Give
your
me
lordship
liberty
grants
to-
that leave, then it is okay. But my lord, I was praying this, my lord, your lordship will keep this pending. No, I'll tell your lordship, my lord.
Sir, Sen, because that matter, I think. Show me the order.
My lord, we have mentioned it, sir. I am saying this, my lord. Kindly see the stages, how many times from here to there, here to
Mr.
there.
Sen, that was hard. My prime impression was that this application is to be transferred and to be hard. That matter to be decided. If you are not in your mood today, I can keep it tomorrow also. But
If that is your lordship's order, then my lord, there is no point keeping it, my lord. But kindly,
but Mr. Kaur, please ask your counterpart also to cooperate with this.
Should I,
No.
from my end,
That I will take care, Mr. I'm only asking you
then, my
so
lord,
that
some time also must be fixed. My lord. They
for what?
decide the transfer
Mr.
application.
Sen, let it be filed. Mr. Sen, let it be filed first. Otherwise, we'll be filing, giving a direction.
No,
Mr. Sen,
because of the special facts, kindly see how many
I
times.
appreciate that, but it will be putting undue pressure. Directing to file, so nothing is before the commission. So I will be directing now to expedite.
No, so therefore, kindly keep this pending, my lord.
If
Because if then I only say what they we do not know what is the situation there. Your lordship, we will only file pursuant to your lordship's leave. That is done. But thereafter, my lord, what is the situation? Again, I will have to come on the same prayer. No, it is not justified, my lord. Kindly for a pleading and my lord,
the forum will understand, Lord, the
Mr.
gravity
Sen,
of
from
you-
here to there, here
if you
to
make a submission with regard to the urgency, all the judicial officers, court, wherever it is, they will appreciate. But Mr. Sen, if you say yes, all matters are to be taken up on an urgent basis,
that.
it's
We are also
difficult.
that unreasonable.
So you have to make that prayer. You have to, what is the urgency? You have to
No,
make that
just
submission.
kindly keep it pending. Well, let us see what is the status there. Then we will come back and report, and your lordship will dispose it of. But your lordship is giving me the leave.
Yes.
Just kindly keep it pending for 7 days.
No,
Let us file a
7 days, nothing will happen, Mr. Sen. Asun.
Calls to your lordship, there is grave urgency in the matter. 28th is the last date fixed for trial court, and if I don't take any steps on 28th, the matter will be dismissed by the trial court. So,
You have mentioned yesterday.
yes, he let the matter appear today in supplementary list.
I have directed the matter to be placed, madam.
It will be
Ask
tomorrow.
your clerk to inquire when it will be.
No, I inquired. They say it is not.
Item number,
My,
uh,
it will be tomorrow. Deeply obliged.
item number one.
My lord. To praise the one. You know, my WhatsApp, he send the later one through WhatsApp. Man.
It has been submitted, Mr. Theta to 3 p.m. আছে।
Item number 6.
6.
6 then.
Item number?
4, my lord, I am for the petition.
Yes.
So there is a direction for service, but my lord, as per the track report, the okay, wait, ঠিক আছে। The defendant
Yes.
the
What? You said that no opportunity was given to you. What opportunity was not given to you?
that I am placing, my lord, kindly takes up, my lord, the after the trial court judgment when the appeal has been preferred during pendency of the appeal, my lord, page 41 of the my lord's brief. This is, my lord, an application, my lord, for amendment of written statement at the appellate stage. As your
You are
lord,
the defendant in the
the
suit.
defendant,
Yes.
defendant appellant in the my lord appeal.
Yes.
My lord, this application is for amendment of written statement. My
Yes.
lord, the schedule as page 43. This has been allowed by the order, my lord, if your lordship takes up. There are 2 orders, my lord, to that effect is being annexed to the order sheet. One, my lord, the certified copy obtained by my client, my lord, that your lordship will get, my lord, the first, my lord, set of certified copy, order number 16, dated 5th December 2024.
Order number?
Order number 16, dated 5th December 2024. Twice, my lord, this order is being, my lord, annexed in the instant
Right.
revision.
Yes.
In the instant revision, my lord, kindly compare. My lord, that's there, my lord, lies the difficulty. My lord, the second order from that bunch of certified copy, my lord, the order number 16. Kindly, my lord, side by side compare these 2. Since there is no pagination, my lord, I could not assist your lordship regarding the page number. Has your lordship got, my lord, these 2?
Yes.
So, my lord has got that this is the amendment application in connection with the written statement of mine. But in the first, my lord, the order, the certified copy, it transpires that Milord, the court has misconstrued it once in a plain, thereafter in memorandum of appeal. So Milord, there is a discrepancy. That prompted me, Milord, the first bunch of the impugned order, which Milord, my Lord has seen, kindly turns over thereafter. Or rather, your Lordship takes up the second bunch. Milord, since there was a discrepancy as per this Milord order sheet, I took out an application under order or under section 151, 152, and 153 for correction. That your Lordship will get Milord the second order impugned before your Lordship by order number 17 dated 23rd of December 2024. Because there was a discrepancy in the order. What the learned trial judge done, today, that order number 17 I am reading, today is fixed for filing amended memo of appeal. So, according to the tenor of the previous order, which is telling as per the order sheet I have annexed, the first bunch, the learned judge is recording, today is fixed for amended memo of appeal. Learned advocate for the appellant file vakalatnama along with application such and such. This is for correction, Milord. Appellant files amended written statement. We correctly done that because the correction was copy served such and such, fixed 22nd of January 2025 for hearing of appeal along with the petition. So Milord, it's kindly turns over the page. 22nd of December, now the today is fixed for hearing of appeal along with petition. Learned advocate for the appellant filed petition on the ground as stated in the petition. Respondent files hazira, hard considered. Fix such and such for filing written argument in respect of petition under section 151, 152, 153 of CPC along with appeal. Milord, my application under order 41 rule 27 is also pending. Because once the written statement has been amended, I took out an application apropos to the amended.
Where is that application?
Yes, Milord. Page 50, 50. These two was filed, Milord, at the same time. Milord, page 50.
When did you file this? When this application was filed?
This order 41 rule 27 along with written statement. That will order 6 rule 17.
Along with order 6, what? Give me the
Milord,
date.
kindly takes up not order number 15. Order number 15, your Lordship will get it.
Order
Today is fixed for hearing of appeal. Sorry, Milord. 15. Oh, acha. 14 ta to annex nahi. Second bunch acha. Then your Lordship takes up order number 14. Yes, my learned friend is correct.
Order number
14, Milord. 13th of November 2024.
yes.
Today is fixed for hearing of appeal. Appellant files a petition praying on the ground stated therein along with two separate petition under order 41 rule 27 read with section 151 and an application under order 6 rule 17 read with section 151 supported by affidavit such and
Yes,
such.
yes.
So Milord, these two was filed, one in segregation allowed. I could understand, Milord, that 4127 will be hard along with the appeal. But 151 application I shown before your Lordship, the first bunch of certified copy of the order itself shows that there are discrepancies. That prompted me to file an application under 151. When I took, Milord, for filing of the present revisional application, the entire order sheet, it reflects that without even anything to be done on the earlier order, a separate order sheet has been prepared, which will not tally, Milord. I have already, Milord, shown before your Lordship from the other. And my 151, I could have understood my 151 has taken into consideration and allowed an order is being corrected. So my 151 was pending. Now, Milord, kindly now comes back, Milord, to the last order number 18, which I was placing before your Lordship.
Order number 18.
18, Milord.
Yes.
So 27th of March 2025 for filing written argument. Milord, the written argument will come after the deliberation of oral argument between the, Milord, the learned advocates. That was not done.
It's so.
Milord, that commercial court, Milord, yes, commercial court, there prior to that, Milord.
Show me the provisions of written argument in normal courts. What is the provision?
Right.
Which provision you are checking?
That there is an amendment, my lord, and this written argument, my lord, was brought into.
Under what provision?
May I just.
Kindly come to order 18 rule. Three capital A.
3 capital A, yes.
Yes.
Shall be form parts of the record, yes.
So it's not after. It's not after.
No, but my lord, provision, any party may address oral arguments in a
And
case.
shall before he concludes the oral argument.
Yes,
Yes. So it's not after what you are saying.
no, my lord,
And that will be clarified by 3B.
shall be simultaneously furnished to the opposite party.
Yes.
I am not also on that. Not kindly consider, the learned judge has, I have done also. It's my grievance is not on that.
So why are you on that? Yes.
Yes,
Yes. Now what is the difficulty?
151, 152, and 153, along with oral argument in connection with the main appeal.
Submitted your written notes of argument.
Now kindly takes up the next order. The regular PO is on leave, so next date was fixed on 2nd of May.
Yes.
Kindly takes up 2nd of May.
Yes.
That was PO is on leave, hence fixed on 22nd of May. Now on 22nd of May,
You have filed your written
yes,
argument.
kindly consider appellant's file written argument, let it kept on record. Learned advocate for the appellant also.
What is this 151 for?
This 151 is for, my lord, kindly takes up now that page 73.
Yes.
First, my lord, we first take up page 72. Earlier also, I filed a put-up petition saying that let my 151 application for correction to be done first. But that was not done, my lord. That was kept pending along with the hearing of appeal. Now, page 73 kindly takes up. My lord, I insisted upon court, my lord, to frame a point of res judicata because, my lord, I have taken the plea of the other suit in the amended, my lord, written statement apropos my application.
In the written argument, you have raised your point of res judicata. In the written notes.
So that I have to check. देखें सेटा. Now, my lord, what I am on, last order number 21, your lordship, kindly to check, sir.
Yes.
Appellant's file written argument, let it kept on record. Learned advocate for the appellant also files an application under section 151 CPC. Let it be kept on record. It will be taken for consideration at the time of delivery of judgment if required. Opposite party files hazira through learned advocate. Fix such and such for delivery of judgment. Lord, my contention is that the deliberation of oral argument has not been made at all because my application in respect to 151, 152, that was for correction. I was under the impression the order sheet remains as it is that I have annexed in the first bunch.
So your amendment has not been allowed. You are under that impression.
No. My amendment was allowed, but that was a faulty order since I have been directed to
Which
correct.
is the faulty order?
I have shown before your lordship.
No, which one is according to is the faulty one? The earlier one or the later one?
It is for the court to decide.
According to you.
Learned judge has done that. According to me, what
Mr. Mukherjee, you have taken steps on the basis of which order? You have filed the written statement. So you have acted on the basis of the second order or the subsequent in the subsequent bunch.
The subsequent bunch will come later on. I have annexed.
Mr. Mukherjee, you have taken steps on the basis of the subsequent order.
Very well, Miller. I have done that because I have done.
That is what I want to know.
My application for amendment of written statement.
Yes.
Application allowed.
Yes.
Learned judge, in the order sheet, various typographical mistakes are there. That may be inadvertent. I file an application. I was under impression my application will be taken up first. This will be regularized and thereafter I will be taken chance to make oral arguments.
So according to you, you could not make any oral argument.
Yes.
That's yours. Yes, Mr. Mukherjee, what do you say?
And Milord, one thing on affidavit, Milord, this Milord, when the petition has been affirmed, the learned Milord, my client have affirmed that yes, on that day when the judgment was reserved, the learned judge have not even sat on that day in ageless. On affidavit, he has affirmed.
Yes.
How in a suit for eviction, how the appeal could be delayed? This is the instance, my lord. Kindly see the order sheet.
Yes.
But he has annexed the entire order sheet, my lord. But kindly see the certified copy of the order from order number 7.
No, Mr. Mukherjee,
I will.
only one thing, according to them, they have filed the written notes of argument, but they have not got a chance to make oral arguments.
I'm showing to your lordship.
Oral arguments are made according to you.
Kindly-
Show me that oral arguments were made.
Kindly see order number 7.
7, yes.
This is the first instance, my lord, when the appeal was fixed for hearing. I'm just first showing their conduct. They prayed for time. Kindly see next order, order number 8. Hard argument in part. Prayed for time. Then next. Again prayed for time, next day. Then what happened, my lord? I came up before this court. But because they are delaying the matter, I came up for early disposal of the appeal. But kindly see this order. Order passed by this honorable court. Because, my lord, every day when the appeal is fixed for hearing, they are praying for adjournment on the ground of senior. Now, my lord, this honorable court directed for expeditious disposal. Now, what happened, my lord?
No, this is not the order of expeditious hearing. This is this order which I have passed in this matter.
Oh, I'm sorry. This is the order.
Yes.
Now, my lord, your lordship will find order number 9. It has been specifically observed no further adjournment shall be granted. Now, what happened? Thereafter, they filed an application for amendment. That was allowed.
No, but how do you reconcile two orders?
Yes, but that is absolute. I have nothing to say because this is a ministerial job. What happened, my lord? In the order sheet, it has been recorded that the my lord, they have to file amended, my lord, plain. That amended
Written statement.
but that is a ministerial job that court has corrected. My instead of memorandum of appeal, now taking that advantage, they filed an application for 151, 152, 153. Now court has corrected, my lord, I have nothing to say. Whatever order your lordship will pass. Now what happened, my lord? After that, again, my lord, kindly see. Now, my lord, this order, the court directed him to file written notes of argument. He took 2 days time. Now court has ultimately now when the appeal has been now when he found nothing has been done, he has filed an application 151 that the matter be sent back on remand. Kindly see the application. Kindly see 151 application. My lord, at page page 73, kindly see the prayer. Prayer will be at page 74. How the appeal can be delayed, this is a glaring instance. This is the application. Now, court said that I will consider that application. If necessary, I will pass necessary order. Now, what he wants today before your lordship? Now, he wants that he has not provided an opportunity of hearing. But judgment has been fixed on such a on August, my lord. But kindly fix the date from here, my lord. If he wants that he want to argue, kindly fix 1 date or 2 date. Let him say how he conclude the argument. But his only intention to delay the appeal. Now, I have shown to your lordship appeal was hard previously. And now, when the appeal has been finally fixed for hearing, he filed application, send back the matter on remand on this ground. The court said, kindly.
This date is on 5th of August.
25th August. But kindly see order number 21.
25th of August.
My lord, written notes filed after 2 days. Adjournment then. And conduct I have shown from the beginning. In the suit also, my lord, I have twice come before this court for early disposal. If he wants, my lord, he could not argue, my lord.
Mr. Mukherjee, only difficulty is that
Kindly fix the date. If from here, kindly fix.
that is the difficulty. I do not know the business of the appellate court. How can I fix it from here? What I can do is on 25th of August, I can direct them to make.
Then, my lord, But
Because,
20
because Mr. Mukherjee, preponing may be a difficulty.
but
Then after,
giving the, I'm the respondent, he is the appellant.
yes,
Let him file a prepone application, my lord. I will kindly record my submission. I will not object. Let him file an application. He want to argue. I will not make any objection. Let court prepone, my lord, because, my lord, his only intention that 25th August no judgment be delivered. That is the only intention, my lord. Kindly see the order which is challenging. Kindly see all the order.
yes,
Order number 5th December 2024, 23rd December 2024. If that be so, kindly see the affirmation date July. Where is the explanation? If I put this question to myself, where is the explanation? Although, my lord, in the 227 we know, my lord, there is no explanation, but there must be in the body of the petition, there must be an explanation. 25th
they have challenged the order of 22nd of May also. They have filed it in
Very
July.
well. First 3 orders, if your lordship is of the view, I'm giving the consent. Kindly see the first page.
5th of December 2024.
Yes. 23rd December 2024, 22nd January 2025. If 3 orders your lordship consider, where is the if I put this question to myself, where is the explanation in the body of the petition? I kindly asked him to file an application for preponement. Kindly record my submission. I will
Yes,
give the
Mr.
consent.
Mukherjee.
Let the judgment hard and judgment be delivered on that day.
Challenging the occupational charge, the tenant come before you, or even an appeal. After
Challenging the occupation charges.
occupation in appeal, my lord, I am, my lord, the landlord, my lord, I have owned before the court below, my lord, trial court. In both cases, they lost. They filed a suit for declaration that tenant
What
not.
is the other side?
I don't know, my lord.
You are for the opposite party.
I am for the opposite party.
You are for the petitioner.
Yes, my lord. Mr.
Yes.
Mukti or I appearing in this matter, my lord, I praying for not today, my lord.
My lord,
Why?
please suffer.
Why you are praying for not today?
Come to court today, my lord. Personal difficulty, he did not come to court today.
He has not come to court. Not today.
My lord, remain in the same position tomorrow because otherwise, my lord, my
Yes,
appeal is
next,
suffer.
next.
Item number 6.
It's not a time for the petitioner.
Yes.
The suit for declaration that the agreement entered into between the parties. Large is appearing, but you will also kindly hear and dispose it of.
When it is expiring.
My lord, I took out an application, my lord. It expired, my lord, sometime in October. My lord, immediately after the opening of that, my lord, I took out an application.
What is the impugned order?
Impugned order is that, my lord, this is a suit for declaration, my lord, that the agreement entered into between the parties has been cancelled, permanent injunction and recovery of possession. My lord, the declaration has been granted, my lord, that, my lord, the agreement has been cancelled and recovery of possession decree was passed to that effect, my lord, so far as the recovery of possession is concerned. But they preferred an appeal that has been dismissed. Now, my lord, I took out an app, my lord, I put the decree into execution, and my lord, when the bailiff went to the, my lord, execute the decree, my lord, he was registered. I took out an application for police assistance. My lord, now, my lord, at the time when the police application was allowed, when, my lord, the bailiff went to execute the decree, my lord, the bailiff only, my lord, giving possession, my lord, so far as the tank is concerned. So far as the, my lord, part decree, my lord, was part possession was, my lord, granted, and so far as the, my lord, the other.
Give me a minute. Give me a minute.
My lord, I am not ready with the main application, my lord. If it is
All right. Ashun, scan 1 of 2024. This is an application.
petitioner, I am the plaintiff.
Every service filed in court today is taken.
I am the plaintiff, my lord. Amendment of written statement has been allowed by dint of the order impugned. My lord, the interim order has expired. My lord, this is the affidavit of service, my lord,
Of what?
of both the CAN application as well as the civil revision.
Of both. This is scan 1 of 2025.
Yes.
The learned advocate appearing for the petitioner submits that pursuant to the order passed by a coordinate bench, the civil revision application has already been served. Full stop. He further submits that the copy of the application for extension of the interim order being CAN 1 of 2025 has also been served upon the opposite parties. Full stop. Every service filed in court today. Affidavits. There are 2 affidavits.
No, in one affidavit of service,
The composite affidavit of service filed in court today is taken on record. So, in spite of service, none appear
My lord, my lord, since all the parties have appeared, my lord, the nature of the order impugned, my lord, is ad interim order refusal in a municipal appeal. My lord, statutory appeal, my lord, the ad interim order was refused. My lord would kindly
Demolition order.
demolition order. But my lord, there are three things, my lord. One, my lord, I have the sanction plan. My lord, I have the supplementary affidavit to support that. Two, my lord.
I'm directing the miscellaneous appeal to be
Yes,
disposed
my
of.
lord. Let it be disposed.
Just a minute, my lord. Your lordship, there was sanction plan was there. It was sanctioned 63.18 square meter. But actually he constructed 117.56
All
meter.
right, so there is a statutory appeal. You have passed an order of demolition.
There is some flaw that may be available, that is available. But my lord, here everything was complied.
All right,
You-
then the appeal has to be dismissed. It could not have been kept pending.
Yes, my lord. Then
So I'm directing the miscellaneous appeal to be disposed of. What is the next date fixed?
next year it faced. And because there is stay in them up to month of July.
All right,
That's it.
so I'm directing and you are appealing for the complainant.
I'm for the respondent number 5.
Complainant.
Yes, I'm.
So you are the complainant. So both of you enter appearance. I'm directing yes, Mr. Banerjee, what
Well, I'm the municipality here.
My lord,
for the municipality. So you have to enter appearance in the miscellaneous appeal. I'm directing the miscellaneous appeal to be disposed of.
yes, my lord.
Let me just short period, your lordship.
Short period.
That
That is why, so as soon as the appeal, because unless the appeal is disposed of, so
Your lordship would kindly take the order in
I,
SRAD 7th of July. They have not yet appeared.
it has been hard. The contempt proceeding is going on.
Yes.
where
Before my lord Justice Kaushik Chandra.
My lord, I tell your lordship.
Everything was done.
They have received. They have received.
sir, if you say so, I will be saying that they can challenge the demolition order in a writ petition. Because you will be proceeding with the contempt and they have gone before the statutory authority that cannot be made nugatory.
After long period, they have gone.
Yes.
In the meantime, there is order.
Yes,
from Justice Chandra.
All right, section 5 can be dismissed then. It's within time or out of time.
My lord.
You have filed the appeal out of time. Or
No.
Then
Within 7 days, I prefer the appeal and not
My lord, there is deviation in all respect.
My lord,
That's why.
sir, let that decision be passed by the appellate court because the appeal is pending. If you execute the decree during the pendency of the appeal, what remains in the appeal? What will be decided in the appeal? And if he succeeds in the appeal, what will be done? And in the meantime, demolish. You will bear all the costs. Then
No, there is no such question.
Then
There will be no such question. Municipality will not be.
that is why I'm directing the.
Civil dispute in this matter.
That's
But the
My lord, there is a partition suit pending and there is an order of injunction also.
just to drag the matter, nothing else.
That is why I'm expediting. I'm not allowing them to drag this matter.
In this way,
It's
they are.
application under Article 227 of the
judge will not be influenced by any of the observations made, but
What observations are
they have submitted.
are not, they are submission only. So এই যে ওনার সাবমিশনের পরে আরেকটা লিখে দিন of time. You have a duty, you have the councillors who have a duty to look back. When the construction was raised, you did not, you kept your eyes closed.
From the very beginning, we serving notice, all
Yes,
records are there.
You could not have, you could have taken prompt steps,
He could
stop
not,
work notice,
he could not bother about to
but
here.
you have allowed him to make construction. Then someone, you waited till someone makes a complaint before you, then you will look for your subdar and pass these orders.
My lord, the
Don't say all these things, I am aware of those. Yes. Yes, call the next matter.
Leave may be granted to amend the order dated two orders, my lord, 1st March 2025 and 17/4/2025.
I could not follow.
Because in the cost title manner, only order dated 1st March 2025 has been mentioned,
Yes,
along with 17/4/2025. The certificate copy is added.
maybe. Maybe you have chosen to challenge because you are,
Is why
Mr. Rai, your instruction is to challenge only one order.
then
There is nothing on record to show that the petition instructed you to.
that is why
Mr. Rai, you are annexing in the earlier matter, Mr. Mukherjee has challenged 3 orders, but he has given 2 bunch of certified copies.
no, I am also annexing both the certificate.
Maybe. Yes, yes. What is the,
Now can I turn to the order
what is the order impugned?
Yes. In the title appeal manner, the suit was decreed. Plaintiff is the
In the title appeal, the suit was decreed.
suit was decreed. Suit was decreed.
Started by saying the title appeal, suit was
Suit was,
decreed.
suit was decreed by declaring the share of the declaring the right and interest of the plaintiff. Against that manner, the opposite party preferred an appeal. In
Opposite
appeal,
party preferred an appeal.
in the appeal, they filed an application for injunction under order setting rule 1 and 2.
Yes.
Now, man, can you consider how it has been disposed of?
Order
Other
that rule
advocate-
1 and 2
Yes,
was allowed.
allowed. Ex parte,
Where is that?
that is the 17/4/2025.
17/4/2025.
Yes.
No, that order is not in here, certified copy. Certified copy last order is 27th of March 2025.
এটা আমারটার মধ্যে তো আছে তো।
No, no, Mr. Rai.
Yes.
Where? Please check up.
No. I am not.
In your copy, it is also not there.
It is there in my copy.
It is there.
Probably one advance.
Check up. Din to. Nothing is there after that. Yes. So, you have the certified copy.
Photocopy of the certificate copy is with me.
Are Vishwajit. He has created this problem. Vishwajit has created this problem.
I have asked him to stand over there. Now, Madam, can you take up the order number 2 dated 1st March 2025?
Order number 2 dated?
1st March 2025.
Yes.
This is an application, my lord, can you consider allowing an application ex parte?
Order 39, Rule 7.
Rule 7. What is the findings, my lord, can you record that? What is
That is the application.
Nothing. I have not been served. I have not been served.
That is in aid of injunction.
I could not understand the end of injunction. Suitor's degree.
Show me the injunction order.
Yes. Injunction order. Looking. One minute. এটা দেখি। নিয়ে ঘুরে বেড়াচ্ছে। এটা আছে গো।
So, commission was held.
It was held.
Sir,
Now, my lord, in the end,
I have given you liberty to challenge this.
my lord, leave me granted, I can challenge.
Because the certified copy is also not here. It is also not with you. Ashun, this application under Article 2 Yes,
The degree holder is the petitioner before your lordship. The suit holder, degree holder.
trouble has started.
Started, but the court has created much more.
Yes,
Whether my lord a suit for declaration from an injunction, degree granted. Whether in anticipation there is a threat, violation of the permanent degree for permanent injunction, I can avail the opportunity to file an application under Order 21 Rule 32 for implementation of the degree by a
I could not follow you.
suit for declaration of permanent injunction.
Declaration and permanent injunction degree passed.
Degree passed.
You have put the decree into execution.
On the ground, that is why, my lord, on the ground there is a threat to violate the degree of on the threat. That is why, because I am using this word on the basis of the threat. The trial court is the executive court is of the opinion, unless there is a violation, I cannot pray for the same actual violation. Whether I can avail this opportunity to execute the decree,
Where is your tabular statement? Show me.
yes, that your lordship will find at page 23 at the bottom. Where is that? My lord, sorry. Prayer is made that a bailiff may be appointed where you go to the local upon beating drums and posting the flag in the four corners of the scheduled property. Thereby proclaim the shouting allowed the defendant here.
How that can be granted in a decree for permanent injunction?
It is only for
Right. Order 21 Rule 32.
32
Please take up Order 21 Rule 32.
injunction.
How it can be done by
Yes.
fixing the flags?
There is no dispute so much my position is concerned.
Yes. But there's a manner in which a decree for permanent
Yes.
injunction is to be executed.
Now one can
Show me
consider
that-
Order
that
21
this is permissible under Order 21 Rule 32.
32, my lord. If you logically consider Order
Yes.
31 Rule 32 once.
Yes.
The doctor.
You want a big book, Mr. Rai?
Huh?
You want a big book?
No.
Can you read from that?
Yes. We are the advocate, my lord. We are habituated in everything.
Yes.
Where the party against whom a degree for the specific purpose, my lord, can skip out the same. An injunction has been passed, had the opportunity to obeying the decree and has willfully failed to obey it.
Yes. So and is there. So he had an opportunity of obeying and has willfully failed to obey. So these two things conjunctive.
That was
And-
considered. That was considered. What is the basic?
Yes, proceed thereafter. The decree may be enforced. Yes, you had difficulty in reading from that small book.
No.
Yes, yes.
Yes. An opportunity to obeying the decree and has willfully failed to obey it. The decree may be enforced in the case of a degree for restitution of conjugal rights. Can be considered the attachment of property in case of degree of specific purpose of contract, or for an injunction by his detention in civil prison, or by attachment of his property, or by both.
This sole substance. So this relief could not have been paid, Mr. Rai.
No, that came up for consideration with the Honorable Apex Court. What only it will be restricted to that or something that one is subject to question, my lord?
Show me.
Yes. And yes, may I read out, my lord? Where the easement, it is, may I read out because I could not get photocopy in the morning, my lord? I hand over to your lordship. The appellate court therefore found, though the degree for the earlier occasion was satisfied, since the conduct of the constructed shop obstruction the free flow of the passage and application for example 2132 could be laid to enforce the injunction granted in the suit in respect of the aforesaid area. It is contended that the High Court has proceeded on the premises that the rights of the parties are required to be adjudicated under 22 of the Easement Act. The view of the High Court is clearly in error. It seems that once the degree for perpetual injunction, mandatory injunction has been passed, it's become final. The judgment letter is required to obey the degree. In whatever form he obstructs, it is liable to remove for violation and natural consequences the execution proceedings 2132. After that, it was held. In this case, the attachment pilot can remove the same portion. The question of section 22 of the Easement Act, it was held And after that, I have every right. But subject matter of the earlier suit, a party should not by his action be permitted to drive the degree for another round of adjudication of his right in the second suit. Here, my lord, once I got a degree for property injunction.
Anything more, Mr. Rai? Now show me the impugned order. Now show me,
Goes to say that unless there is a violation. I am on that.
show me that. And this is what has been held. Was this relief whether can be is permissible under Order 21 Rule 32? The executive court has gone into that, or it has not gone into that.
It was held, my lord.
Execution case dismissed, rightly dismissed. Rightly dismissed.
My lord, can you consider? If
Rightly dismissed.
my lord, can you
The
consider?
relief you cannot claim under Order 21 Rule 32.
Well, a permanent injunction, degree for permanent injunction. Somebody wants to threat. It is a vacant land.
Mr. Rai, it has to be executed under Order 21 Rule 32.
That came up for consideration.
Order
That is why. That is why.
Is that judgment?
And subsequently, my lord, 2025 Supreme Court SCC online, Supreme Court 360.
Show me.
47 pages judgment, I could not find it out today.
Then nothing. Yes, Ashok.
This, yes, that is the, my lord, it is the execution.
Carry in there.
My lord, can you consider in other way? A suit for declaration of permanent injunction. Then what? Today the degree has been passed. Tomorrow there is against the same threat.
This shows, Mr. Rai, you are not in possession.
That is the child court has to come.
This shows the way you are trying to enforce the degree of permanent injunction.
Then one,
Shows
all the
that you are not in possession.
That is why, my lord, there the Supreme Court said that it has not been challenged. Still today, if the order is challenged, degree is there. Whether I am bound to challenge the same.
You need not challenge the same.
Then
But, you
what
enforce
the
it.
degree will
Yes, which paragraphs you are relying upon?
last paragraph, your lordship find.
Last paragraph.
Then what is the use? I
You
put this
can
question
never
myself. What is the use of
separate
passing a
the
degree
legal
for
part.
declaration and permanent injunction?
Liberty would be granted to encouraging if the decree holder makes any construction clubbing the, in other words, the judgment debtor has suffered a decree, no attempt to circumvent the purpose can be permitted. If the decree holder makes any construction clubbing the adjacent property, which is the subject matter, the party should not permitted to drive the decree into another adjudication. Yes.
And
What is the finding of the learned executing court?
third paragraph. Thus, what we find contained in the second page,
Second page.
third paragraph.
Hence it is found.
Thus, what we find from the provision of Order 21.
Second page.
Impugned order.
Sorry. Yes. Oh.
Thus,
second-
what we find from the provision of Order 21 Rule 32 CPC is that the judgment debtor have to violate the degree of permanent injunction and not obeying the same which give rise to the cause of action for filing an execution case for executing the degree. So the trial court, the executive court procedure, unless there is violation, I cannot enforce. But on the threat, I can also enforce. The Supreme Court says that the Appeals Court said not only that, when the last paragraph your lordship find that I cannot be relegated to another suit unless it once violated. Well, what is the violation? That I have been evicted from my position in violation of the degree. Next, my lord. Nowhere in the execution application the degree holder mentioned that the judgment debtor have violated the degree of permanent injunction. My point is that your lordship find after that similar thing is mentioned column after that the findings of the learned executing
No,
court.
this is you have not made any statement that they have violated.
They are threatening.
Where is that? Where
Yes,
is that? They are
that is why.
threatening.
And can you turn to the tabular
Threatening is
statement?
violation. Threatening is violation, very bad.
So violation.
Very, very,
Page
very bad.
23, you will logically consider?
Page 23.
Yes.
Yes. No, page 23,
The tabular statement.
relief period and mode.
Yes.
Restraint from creating any disturbances.
Yes. Yes, you can and there were proclaim the subject.
Ousting the plaintiffs therefrom,
Yes.
failing which police aid may be granted.
So if I prayed something. If my lord is of the opinion that it is not beyond the scope of the, that is
So what,
restricted.
so that much which you are entitled to, that has to be granted. That's your submission.
And now, my lord, whether the actual violation is required or not.
Anything more, Mr. Rai? This application under article
execution for permanent injunction is under order 21 rule 32. But this is an application already filed under order 21 rule 32.
Yes, yes. Order 21 rule 32 does not contemplate the other things.
This rest portion subject to question, my lord. The rest portion, my lord, is of the observation that for the purpose of executing the permanent degree, the permanent injunction degree for permanent injunction, required to be filed an application under order 21 rule 32.
I've said order 21 rule 32 under those are the reliefs as contemplated, no other reliefs. So you cannot beating of drums and those are under order 21 rule 34, 35, 36, not under 32.
Beating
That's
of
the
drum,
distinction.
so but the in West Bengal,
That's the relief you have claimed.
in West Bengal, beating of drums is not there. That is a symbolic position. That is, but the Supreme Court.
So here is not symbolical possession. That's the other way. Yes, call the next matter. Yes, Mr. Mukherjee, can you give me 5 minutes?
24, your lordship, the other matter, your lordship has released it on your lordship's personal ground.
24.
Yes, lordship.
Yes.
Yes, that matter be released on your lordship personal ground.
I appeared on behalf of one of
Yes, lordship.
item number 24 টা একটা order record করে দিন।
Instructed to appear, my lord.
The petitioner before your
You
lordship.
are for the opposite party.
Yes, my lord.
The preemptees is the my lord petitioner before your lordship. In a suit, my lord,
Final order passed.
Initially, my lord, the preemption application got dismissed upon holding that in an earlier suit, not in a suit instituted between the vendor and the preemptees, ultimately it has been, my lord, decreed on compromise that the deed in question is a loan in substance, not an out sale,
Which was sought to be preempted.
which was sought to be preempted. So, my lord, ultimately a preliminary question, my lord, issue is being framed while disposing of the application under section 8, whether this is an out sale or not. In view of the judgment of that, and since there is no challenge thrown by the preemptor of that decree, my lord, passed in that suit, so ultimately it has held that yes, it is an out sale, so no cause of action arises for filing of this suit. This application for
Degree.
compromise degree.
Between
This
the
application for
vendor
and the
and the
preemptees. Subsequently, my lord, the appeal was being preferred. The appellate court found no, since that compromise was taken place in a jurisdiction of the civil judge junior division, so this should not have been a compromise recorded by a competent court of jurisdiction, because according to the learned appellate court, this suit has to be valued according to the market price. Subject to correction, Money Launderers Act, not section 36, vis-a-vis. It's not the executant challenging the execution of the deed under the specific relief act. It's only about the substance of the deed. So, that score, remand was being made, holding that the other issues needs to be gone into, because this issue answered, against me. On the point of
You are
jurisdiction.
agreed by that.
I'm agreed by that.
Mr. Mukherjee, initially there was a sale deed.
Initially, there's yes.
Sale deed. So the
According to the
preemption application was filed prior to the compromise decree or after the
no, prior to that.
preemption application was filed prior to the preemption decree, prior to the compromise. Decree. So the suit was filed. The suit for which was compromised was
my vendor filed a suit against me
prior or after the filing of the preemption application.
After filing of the preemption application.
All right. So your vendor filed a suit saying that it's not a sale. It's not a sale.
It's a loan in substance.
And
so, the deed got null and void.
So deed got null and void. So you do not have any title.
I do not have any title.
What is the locus to challenge this by you at your instance? You have no locus in the property.
It's not about me.
Yes.
The appeal has been preferred. The appeal has been preferred.
Kindly now you are challenging. Yes. You are nobody. Mr. Mukherjee, compromise decree has been
party to that compromise decree.
Yes. But yes, Mr. Mukherjee, you do not claim any right in the property.
But had it been a case, then
have you challenged that compromise decree?
There cannot be any challenge on my behalf. There was a compromise ad idem between my vendor and me.
Yes. So you are a party to that?
Yes.
So the deed
today, today the local under the civil procedure code, may I under the civil procedure code, an aggrieved party in an appeal can always prefer this.
How can you be aggrieved?
Yes, yes, I'm coming. It
Mr.
is
Mukherjee, you can be aggrieved
today
till you have an interest in the property.
Today, I'm coming. Order 22 Rule 10. It's a discretionary relief. Today, suppose, I being arrayed as a defendant, I transfer the property to any third party. Ultimately, suit decreed in my favor, I contested because it's a discretionary relief. It's not that any transfer that has been taken place that will abide by the result of this. If I have been arrayed, whatever the decree that will percolates down to my successor also. So today a decree has been passed in my favor, challenging that an appeal preferred. Appeal succeed. Can it be said that since you, after that transfer being taken place or taken back to the earlier position, you cannot be said to be a person aggrieved and you cannot file an appeal? It is not like a writ jurisdiction. It's an appeal by a person who has suffered. There may be a situation that yes, in the meantime, in the interregnum period, the transfer has been taken place. Today, what happened? Today, the
compromise petition.
Yes, Milord.
Show me the initial sale deed.
Yes, no sale deed.
Yes, which has been declared to be not a sale and is a loan in substance. Show me that.
But today, Milord, whether
please show me
Milord,
that. Let me, no. Let me see that. Please show me the sale deed. Please show me the terms of compromise.
Terms of compromise.
And let your junior find it out. Please give me the dates when the preemption application was filed, when this that suit between your vendor and you were filed. What is the date of compromise decree? Please give me these 3 dates. Mr. Mukherjee, are you in possession or you are not in possession of the suit property?
The possession, according to the
according to
compromise decree.
According to you, are you in possession or you are not in possession?
No, they are in possession.
You are not in possession. All right. So,
page 28 is the judgment of compromise. That was passed on 10th of July 2019.
When the preemption application was filed?
The exact date, my lord, I have to check. But yes, 7th January 2019, if I'm not mistaken.
All right, 7th January 2019.
Yes.
Section 8 filed.
Section 8 filed.
And when your suit was filed, not your suit, your vendor filed the suit.
Vendors. Vendor suit, my lord, the compromise application, I believe that was filed on 2nd of April 2019.
2nd of April.
That is the compromise application itself filed.
So it must be
prior to that
in close proximity, because when this preemption application was filed, then that suit was filed. Immediately thereafter, this compromise petition.
We can go by the. This is your lordship has vast experience. This is from Purva Mednipur. This is the common practice over there.
So compromise decree is 2nd of April 2019. So it's after the suit was filed.
Yes. I said
yes. Next, yes. Where is the terms and conditions?
Yes, of that compromise? Takes up, page 34. It starts. The terms are page 35. Point number 2 is the.
Give me a minute.
Milord has got Milord this. Now Milord kindly takes up page 28.
You are trying to show something from these terms. I stopped you. I have seen you.
Well, your lordship has seen Milord nothing to. Milord, page 28, kindly see Milord.
What is page 28?
28, Milord, is the judgment passed, Milord, on the basis of this compromise, order 23. Order number 7, dated 10th of
10th
July
of July.
29.
So 10th of July is the compromise decree passed.
Yes.
So not 2nd of April. 2nd of April is the compromise petition filed.
Petition, Milord.
Sorry. Compromise.
I cannot give your lordship the exact date of filing of the suit because that I have not.
But that's post section 8.
Post section 8. Milord, I will take your lordship to the averment because these facts has been disclosed in my written statement to the preemption application.
This compromise decree. And Mr. Mukherjee, when did you enter appearance in
Yes,
this
Milord,
preemption?
I'm coming. Milord, no. When I enter appearance again, Milord, it's very difficult to say. But Milord, kindly takes up page 18.
It's pre-compromise or post-compromise decree?
That I will have to take instruction. Milord, but Milord, your lordship takes up page 18. It starts my written objection. My written objection. Why I say? Because my lord can say.
It is the date of affirmation of the written objection.
Also written objection. Milord, it has to be, the written objection has to be filed after that compromise because kindly take
The compromise averments are there.
Yes. Yes.
Yes. Page 18 is the
I also take your lordship, Milord, to the way that after this disclosure, what prompt steps, Milord, the preemptor may have taken. Milord, the learned trial judge has taken note of it. Milord, while, Milord, in the cross-examination, the preemptor, Milord, has given that yes, it is his knowledge that this has been done.
Mr. Mukherjee, did you get possession of the property at any point of time? Not.
That was the terms of compromise.
Have you stated that in the written objection that you were not put into possession? Show me that paragraph.
Kindly see paragraph 10. Milord, I know, Milord, your lordship will ask me that. Kindly see paragraph 10.
Yes.
Milord, may I skip, Milord, may I give your lordship the paragraph number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Madam, you can take your seat. You have a chair behind you. Please take your seat.
12, Milord, paragraph 10, 12 line from the top. If your lordship skip over, your lordship will find, Milord, that ডিগ্রি বলে ক তপশীল সম্পত্তি কিংবা জাহানাবাদ মৌজায় সাচানসার সম্পত্তিতে এই প্রতিপক্ষের বিন্দুমাত্র সত্য দখল ইট হট টু হ্যাভ বিন দখল না থাকা সাব্যস্তে শ্রী সাচানসাজ ডিগ্রি প্রাপ্ত হইয়াছে. So Milord, the compromise itself records that I was not in possession. It was a loan in substance.
Show me from the terms that has been stated that you did not have possession.
Milord, kindly
Which terms of the compromise decree says that you were not in possession?
Milord, kindly takes up দলিলটি illegal, void, পণ্যশূন্য, not acted upon থাকা ও তাহাতে out and out did.
That is with regard to possession. Anything stated in the compromise petition with regard to the possession?
Milord,
there are only 3 clauses, effective 3 clauses. First clause says with regard to title. Second is with regard to the declaration as to the nature of the deed. Third is সত্য প্রচার or চিরস্থায়ী নিষেধাজ্ঞা. Nothing with regard to possession. So your statement in paragraph 10 that it was declared in that with regard to possession, that
need not
beyond the
Milord, the cause of action in respect of Milord, the preemption accrues in respect of the deed in question.
only yes, yes.
Milord, with regard to the possession, Milord,
So জাহানাবাদ মৌজা এই প্রতিপক্ষগণের বিন্দুমাত্র সত্য না থাকা সাব্যস্তে, so that's not correct. So দখল is not there. Yes, next proceed.
now Milord, this has been pleaded, Milord, in the Milord written statement, written objection. Now Milord, kindly takes up the trial court judgment, the latter portion.
Could you find out the cell deed, Mr. Mukherjee, in the meantime? Let me have a glance of the cell deed in the meantime.
এটাই তো রে
you have another copy of this? Because
Your lordship is about to, my lord, looked into whether the possession was handed over or not. But
No.
now the Honorable Supreme Court has made it
Other
clear.
things- no,
My
other things I want to see from this. Do you have a copy of this?
no, my lord,
All right. Please make a photocopy of this and give it to me.
I will, my lord, I will.
Have you annexed the preemption application?
Yes. The
Page
preemption application, very interesting. The preemptor himself has stated that there is an amicable settlement. One portion is, my lord, delineated, transfer by, my lord, southern side by one, northern side by one. So, my lord, it's a, my lord, page 10 it starts. But today, my lord, I am not canvassing with regard to the other aspect, since the remand order which I am challenging is based on only one aspect, that whether the jurisdiction of the learned
vendor is not a party in this preemption application.
vendor
Yes.
is not a party.
Yes. So there were two purchasers. Because
Yes,
there are
my
two
lord,
opposite
we are the
parties.
purchasers. We are the purchasers.
Two purchasers. Two persons
Two
purchased.
persons, Showman and
All right.
Soumitra.
Yes, yes.
So vendor is not a necessary party, my lord, your lordship knows. So
I'm asking you whether the vendor is a
yes, so the cause of action in respect of filing the application for preemption accrues in respect to a deed. Whenever, my lord, a transfer took place, my lord, the right accrues, the preferential right. Here, once the transfer took place in by virtue of a deed, which has been the nomenclature of which has been, my lord,
It's a sale deed.
is a sale deed.
And that has
Ultimately,
been compromised.
ultimately, my lord, no, my lord, not only on that. Whatever the nomenclature is, ultimately the competent civil court has declared this document is a null and void.
Whether in section 8 one can override that.
No, I am not. Look, there is no question of overriding, because it's not that the right of preemption has been declared by a competent court and thereafter, my lord, the deed has been declared to be null and void. It's a case that yes, this has been done, informed by way of written statement. The preemptors waited, did not take any steps, because your lordship knows there are other ways also. Now, order 23, yes, even I am non-party to the suit, I have other avenues. I am here not to give any advice to them, but there are other avenues. My lord, we are also, my lord, fighting, my lord, in other matters in respect to those kind of compromise took place, wherein I have not been made party, though the application for preemption pending. I am conscious, my lord, here, my lord, in one of the case, my lord, where my lord, Justice Basu is hearing, there is a subsisting order of injunction. I took the plea that even if that compromise, that will be in teeth of an order of injunction. In this case, that has not been there. So now, in such a scenario, the preemptor waited in spite of those facts being disclosed in the written statement. Now, my lord, the learned trial judge take note of this, frame the specific issue. My lord, kindly takes up this trial court judgment. My lord, the latter part of the certified copy.
Yes.
Lord, kindly internal page to bold. Lord, kindly takes up, Lord, the internal page 5 of the judgment. Lord, at the top, your lordship will get, Lord, the internal page number.
Yes, yes.
Internal page 5, Lord, kindly takes up the issue number 1.
Yes.
This issue has
This
been
is the relevant issue now.
because, Lord,
This was decided by the trial court only.
Trial-
This issue.
no, by the appeal court also.
This issue, trial court has
Yes, yes.
decided this issue.
Because this issue, Lord, since decided in
If it
favor
is
of
decided, there is no necessity to go into the other issue.
yes.
If it is decided
In favor of the preemptive.
in your favor.
Now, Lord, kindly takes up page 7, internal page 7.
Yes.
May I read from the third paragraph on perusal of Exhibit A?
Yes.
Your lordship.
Yes, yes.
Exhibit A, collectively certified copy of the order and decree dated such and such. It appears to this court that the said suit being such and such was initiated by the transferor of the impugned deed by such and such, Sri such and such, against the transferee of the impugned deed, the opposite party present in this case, namely such and such. The declaration and permanent injunction and the same was decreed.
Subrata, show me what is the relation between the vendor and the.
They are সেইটা
সুব্রত মন্ডল, সৌমিত মন্ডল, সৌমেন মন্ডল।
সুভাষ আর কেশবের ভিতরে কি সম্পর্ক একটু দেখতে চাই। আই এম জাস্ট No, the Soumitra and
Related,
Somen are
no.
brothers. Soumitra and Somen are brothers, my lord.
Yes, yes, no, they are brothers. Any relation with
Subhash and
Subrata?
Keshav. Lord, I'm just kidding.
Yes.
May I read? Lord? In the said suit, both parties have jointly filed a compromise petition wherein it have been agreed that the impugned deed dated such and such in favor of Shri Soumitra Mondal and such is illegal, void, without consideration, not acted upon, and not out and out sell deed, and a security for law. PW1 has stated in his cross-examination that he has no knowledge about the title suit number such and such. He cannot say whether such impugned deed is in existence or not. She has admitted that she has not filed any suit or prepared any appeal to challenge such Solenama decree, though she has admitted that she has inquired the order and decree of title suit number such and such. Now, my lord, kindly turns over. Now, my lord, the judgment has been, my lord, placed. Kindly takes up now internal page 10. Fourth paragraph.
Yes.
In the case in hand, it is palpable clear the exhibit 2, which is neither set aside nor modified or reversed by the
Exhibit
competent
2 is that deed,
that
sell deed.
no, exhibit 2 is, my lord, that, my lord, the order
Oh, compromise decree. Yes.
by the competent court of law that the impugned sale deed was declared as illegal and void, which means that the impugned deed was void from beginning. Once the court declares a deed to be void, it has no legal sanction, and there is no difficulty in saying that the right title and interest does not pass to the vendees of the said impugned deed, and thus the cause of action for such preemption application fails. Now, my lord, skip over that.
So the trial court proceeded on the basis that
That was
compromise decree still remains. So if the compromise remains,
you did not prefer
the
any challenge
deed is non-existent
because it's
so-
declared as void. So, my lord,
it is not
ultimately,
existent.
yes. This finding of the learned trial judge is being disputed by the learned appellate court, my lord. If your lordship, my lord, it's a longish judgment, but I tried to find out some portion which will be
Show me the finding with regard to the compromise decree first.
only on that aspect the trial court has done this. Not the appeal court judgment, not the prior to that, not the. May I take your lordship the relevant portion? Yes, my lord, kindly takes up internal page 19. Straight away.
Give me a minute once. Page 19.
Page 19. Because the recovery of possession may not have one of the factor. Not page 19, has your lordship got it?
Yes.
Last but one paragraph starts with even if.
Even if, yes.
Even if I consider the title suit number, this is the compromise suit. To be one of such suit, he has
No. Prior thereto, please show me this is suit. Where is the
compromise suit, my lord. It is compromise suit.
Oh, yes. Yes.
My lord, may I just then, my lord, may I place, my lord, from page 18 last
No.
paragraph? My lord,
Alright,
because that they are, my lord, the substance of those deeds, because that has been declared. That's why, my lord,
All right.
but
Even if I consider
the suit being title suit number to be one of such suit has to be value his suit and claim according to the value of the impugned deed, unless he does so and file his suit at an appropriate court, the jurisdiction to declare such decree void by the court, particular court, cannot be said to be proper. The question of valuing the suit and relief according to the market value of the property would only arise when the recovery of possession would be paid. Not to mention that
the party to a deed challenged.
I am coming. I will satisfy before your lordship. But the specific relief act, the party to the deed challenging execution to the deed has to value. But here, my lord, it's not of that. He is not challenging his execution. He says the substance of the deed is such. It's not an out and out sale. So this kind of declaration.
So no prayer for cancellation is necessary.
No. Because it is the
So it
execution.
will remain in the records of the registration authority.
No, cannot be. Because once I say,
Unless section 31 decree is passed, that will remain.
Then,
because only in section 31 a direction is passed to the registration authority.
If I say it's void, if I say the nomenclature is bad, my lord, in that event, my lord, I need not, my lord, and my lord, subject to correction by my lord, once that decree attains its finality, the court cannot reopen it. The court cannot reopen it. The trial judge is saying it's a conscious thing, you did not challenge it. That attains finality. So today, a new challenge cannot be made, that too at the appellate stage. The learned judge has to confine himself, my lord, whatever is there. Now, my lord, kindly see, the court is with me.
In the absence of any challenge to the compromise decree in a collateral proceedings, this cannot be reopened.
This cannot be reopened, and that too, my lord, the appellant also did not, my lord, even challenge even before the appellate court. And that cannot be done. My lord, your lordship knows order 23 is a specific bar. You have to challenge if you are non-party. 2022 Supreme Court made it clear that no separate suit, no appeal. It's only by way of an application before the same court. That can be done, my lord. That has not yet been done, my lord. That is the other thing. Now, not
till then, the preemption application should be kept pending.
No.
Otherwise, what should be done?
My lord, that is, my lord, we are not here, my lord, to advise them.
No, I'm asking you.
They have,
let us take a hypothetical case.
Lord, we are not here, my lord, to advise them. My lord, today they have, with open eyes, participated on trial, faced the trial, and lost before the trial court. Now, whatever, my lord, is the position of law, what should they have taken, my lord, that they thrown a challenge? Yes, my lord, there are possible ways. My lord, we all know, my lord, there are ways.
Have to advise their client.
Yes. My lord, if they thrown a challenge before the, my lord, compromise court, what should be done in respect of the even the prior proceeding, whether this can be stayed or not, that is something else to be decided over there. Now, my lord, not to mention that in a suit under Bengal Moneylenders Act, the value of loan would generally decide the jurisdiction of the court, as the case may be. In such a case, it was 160. In this case, my lord, this is also, my lord, not correct, my lord. The value of the suit, my lord, it's not about, my lord, recovery, my lord, of that money. In this case, I find that the value of consideration mentioned in the impugned deed is 1,60,000, which is why the suit ought to have been valued properly and filed before the court which having the jurisdiction to try the same. In this case, the learned court, Civil Judge Junior Division First.
So the appellate court proceeded on the basis of the
pecuniary jurisdiction.
That trial that court did not have jurisdiction to decide. So the decree is in effect nullity.
That my lord, the appellate court has proceeded, my lord, in my respectful submission.
Though there is a compromise decree, it's nullity because that was passed by a court without jurisdiction.
That is, my lord, the finding. My lord, the second amendment, I'm just skipping. My lord,
and
on that,
according to you, the appellate court could not have gone to that extent.
And
in the absence of a challenge
to my lord,
compromise,
because they have known. In the written statement that was being done, and the second limb of my submission will be, even if the learned judge is going on that part, it's not necessary. The executant to the deed is not challenging the executability or execution of that deed. He is saying that it's the nomenclature of the deed, though mentioned as a deed for out and out sale, but so it's not really an out and out sale.
The suit was paying for declaration that a deed was void.
Yes,
it is not
without recovery of possession. Also,
it is not required to be valued as on the market value of that property. So
without the prayer for recovery of possession,
there is also no necessity to pay for cancellation of the deed.
And they are also not saying that the money I want to return back. So this is a compromise ad idem between the parties. At best, the preemptor can say it's a collusion. Yes, at best, yes, he can always say that, because after that,
which is not that,
which is not their case, which is not their case, as if not even in the written statement, after disclosure of the written statement, they have not come out with any amendment that this is collusive, not binding upon me, nothing. So jurisdiction of the court of touching that does not arise. First, secondly, since it's not even required, so the court cannot say the market value of the suit has not been properly valued, so that's why the jurisdiction has been taken away. This is also a perverse finding according to me. And what he has done, the learned appellate court, after this giving this finding, has as if decided the issue number 1 against me. And my lord,
so positive finding on that issue.
Yes.
Not an open remand. Not an open remand.
Not an open remand.
So after deciding that
that's
issue,
why kindly takes up the ordering portion once.
Yes.
That the misappeal being number such and such is allowed on contest and without cost, the original case record is remanded back to the learned trial court with a direction to decide the rest of the issues that have already been framed, except the issue number 1. So he is delivering judgment on issue number 1 and the remaining
So it's
matter-
not an open remand, that
an
so
open
you are
remand.
agreed by that. You are not agreed by the open remand. You are not agreed by the
I'm
open
agreed-
remand.
I am aggrieved by both. Issue number 1 deciding against me, I am aggrieved by that also. And if that be so, there will be no question of remand. If the issue number 1, the learned appellate court is with me, as the trial judge has done, so there will be no question of remand then. And the second aspect
There is
will
a
be
question of remand because the other issues, if the that
issue number, your lordship is with me, because the trial court once decided this cause of action does not survive when the deed got
yes, but the appellate court held in the other way.
The
So if
appellate
that
court held
remains-
yes, that's why. If I
No, if that remains, if the appeal court's judgment survives, then
the
other issues
question-
have to be
yes,
decided.
yes. Then the question of open and remand will come.
One thing, Mr. Mukherjee, the evidences were laid by the parties.
Yes.
So if the appellate court is directed to decide the other issues, because all the evidences are
But
there,
the issue number 1,
so I can keep this issue open to be challenged in a subsequent proceedings, to be challenged at the time of final decision. I will set aside this remand portion. I will direct the appellate court to render a finding on other issues also. Then you can challenge that.
I will lose a forum, in that.
Why?
I will lose a forum.
Why?
Your lordship knows.
No, what for?
Today, because if these other issues will be decided by the
All right, accepted.
that's why. That's why. I
So
will
you are
lose a-
against that order of the appellate court.
I
Anything
am
more, Mr. Mukherjee?
in the 2 limbs. That's why the first is that issue number 1 ought not to have decided against me.
Any decision you want to rely upon?
Today, I am not carrying any decision because
Why?
I was under the impression that it is under the motion stage. My learned friend will appear.
Motion stage, Mr. Mukherjee.
It's
is
very
not,
difficult because
first,
this court-
I have not called upon her. First, if you want to cite any decisions, you can cite that.
Definitely, we will cite. I will cite definitely. This is something that the caption of the suit, the valuation on that aspect, I will cite decision, and also that this particular nullity, declaration of nullity, that cannot be done.
I accept those 2 propositions of yours. You did not cite.
Then,
decision.
your lordship has to express something on which point I need to assist your lordship, because otherwise I could not able to understand what is disturbing before your lordship. I will.
You have understood very well
No,
what
Milord,
is disturbing.
Disturbing.
You know what will be the queries. When I was making queries, you told,
No.
yes, I know.
No, Milord, that was my anticipation. But today, Milord, now I am realizing, Milord, what is on my mind, that is not with your lord.
That is why I gave you an option. If I direct the appellate court to
Kindly-
decide.
Milord, what is disturbing your lordship's mind, kindly express that so that I can assist your lordship on that aspect. So that I can assist. Milord, try to assist rather. Because, Milord, if this issue, Milord, in my estimation, if this issue, the appellate court
According
went
to
wrong.
you, Mr. Mukherjee, your sum and substance of your argument is the right of preemption arises if a transfer is there. So transfer is same because certain types of transfers are exempted. So according to you, it was not a deed of sale that has been decided in a different proceedings by way of a compromise. So if that is set aside and it has been held, it's not a sale deed, the right of preemption goes.
Because
That's
that
the sole and
goes,
substance.
yes.
So you can cite decisions on that.
Very well. Milord, very well. I shall try. I shall cite, Milord, that if that deed goes, so Milord, even if Milord, I know, Milord, if subsequent transfer took place, Milord, there are certain lines of judgment. Yes, subsequent transfer took place. It says no. Once, yes, here
So
that is not the
Mukherjee,
case.
From the facts, I am sure subsequent transfers will not happen. That much guarantee I can give it to you.
No, subsequent transfer has happened. No,
No,
Milord, I do not.
will not happen.
Yes, that's
That much guarantee I can give you.
Milord,
That
also,
instructions, yes, from the facts,
Milord,
there will be no subsequent transfer.
Milord, that's Milord. Nowadays, before
Subsequent transfer, Mr. Mukherjee,
is by way of gift. That Milord immediately after the next day to their wives. I am frightened, Milord.
Mr. Mukherjee, I'm aware.
Yes, that's why, Milord. That
So I know the subsequent transfers will not be made now. You'll be rest assured that will not
So
be
I
done.
need to not assist your lordship on
There
the
are
point.
two things. Subsequent transfers from the preemptive to others will not happen. Subsequent transfer.
MP to my lord lost his right.
No. Prior to that, anything, what right has lost, I've seen those. Next, second is the vendor of the PMT transfer till date will not be done. That I know. That is why I gave you an
My lord, I will have
opportunity.
to assist your lordship that yes, my lord, that opportunity, my lord, will ultimately I will lose a forum. Then, my lord, this question, or my lord, may I take instruction and come back? And my lord,
What? No instructions on
your
this.
lordship is now, my lord, giving me a chance that whatever this, my lord, issue number 1 is being decided by the appellate court, your lordship will allow me to participate on the other issues because
Not necessary. You can.
other issues are materials are already on record.
Difficulty because if this issue remains, because from the tenor of this compromise decree, you do not have a case on merits if this goes on remand. That much I can assure.
No, my lord, that my lord, no.
That
That is
much,
there.
Mr. Mukherjee,
Lord, I have
that much I can assure you that if it is remanded on other issues, otherwise
I'm
this
taking.
compromise would not have happened.
Lord, there are other points
And,
with regard to the special bench
Give me
pending.
the dates when you entered appearance, when the summons was served, when you entered appearance, when you filed your written objection. These 3 dates.
That I will. That I will not from
And
the
then
order.
the other suit was filed. These are the 3 relevant dates on which when
That
you
I
want,
will. That
when
I
you
will.
want.
No,
this to be-
that Milord, it's from Purvo Mednipur. I will have to bring the entire order sheet. Otherwise, Milord,
What?
otherwise, Milord, how can I Milord, show that the date of appearance and all that?
Already you need not show that because from the compromise decree I can get that.
From the compromise
Appeal-
decree, Milord,
appellate-
the date of appearance in the miscellaneous case, Milord, will not come.
In the miscellaneous case will not come.
Yes. The section 8 application.
When this preemption application was filed,
Milord, one stamp I find, Milord, at page 16, 7th
7th of
January.
January.
Yes.
The suit was filed on 2nd of February 2019. I've got that, thankfully. Yes. Page 6 of the appeal court's judgment. You need not bring the certified copy.
Milord, I'm
I've got
trying away. It's not that, Milord, that I will take
I've
that.
got that.
Yes.
So for that, so 2nd of February 2019 is the other suit which has been filed.
But I say at the very beginning, it's latter in point of time.
No.
So, Milord, even if I had a knowledge, Milord, this cannot be prejudged. Milord, the court cannot
No.
take a presumption that yes, after that, since you have filed, so this is
not that.
conclusive.
The court cannot presume that after having knowledge of this preemption application, that compromise.
Yes.
That much
Milord, that has
that
been
court
done.
cannot presume.
Even that,
I'm
so,
with you on that.
even
with
that
you
be
on
so, Milord, this.
Yes, on the other legal issues, when can you address the court? You did not bring any order sheets.
I will
When?
not bring Milord.
When?
Next week, anything.
Which date, according to your,
As per
please
your
consult
lordship's-
your diary.
Your lordship's diary, Milord, your lordship.
Yes, madam, you are ready. What do you want to submit?
No, I am not served in the copy. Kindly direct to.
Oh, you have not served. Serve her a copy today.
Since she was not lodged carrier.
Yes. Now you are getting another chance to something. It's an arguable case, Mr. Mukherjee. You have made out an arguable case. So,
No, I will, no, Milord.
so that is why I'm directing you to serve.
Yes, I have already served.
Any interim protection you have sought?
Not only the 28th July, Milord, this is not the last as argument, Milord, for argument as a last chance.
For argument in the suit. Let me proceed. Nothing will happen. Yes, Ashok.
Not on 28th July.
28th of July. So you come tomorrow with the.
Tomorrow, Milord, this will be difficult. But give me this weekend, I will come back.
Then 28th.
Milord, your lordship
Because
keeps it
28th
after
is-
that. Your lordship keeps it after that. I do not, but I mind that your lordship will not protect me in any event.
It's at the argument stage. Why you waited
After
for
remand, no. After remand, immediately argument fixed. Since the learned appellate court did not say that it is a Milord, open remand, so Milord, the other issues are materials are already on record. That's why. That's why directly posted for her. I think, my lord, something needs to be looked into. I know, my lord, there are other possible ways. My lord, now what is my lord, passing through your lordship's mind, my lord, I will have to think about it and I will try to assist.
That you have understood in the meantime.
I try to understand.
Heard Mr. Mukherjee, learned advocate for the Yes, take it back. Yes.
The preemptors of the petition before your lordship. This is, it was remanded, challenging the state.
Preemptors of the petitioners, again preemption.
Yes. And it was challenged, my lord. Now, my lord, can I turn to,
Any compromise degree, Mr.
no,
Rai?
no, no. What is fallen from your lordship's constitution that was there? Both the,
It was there.
it was there. What is fallen from your lordship's the chronological events? Those judgments also there.
Yes, yes.
Can you
What
go to the
So which order you are challenging?
no, my lord, can you
22nd
turn to
of-
page 19? Order is something, my lord, it
Page
requires the consideration.
19.
Is request consideration by your lordship's court regarding the function of the trial court.
Function of the law. What happened?
This, what is the use of giving server copy? This is the order passed.
I could not. What has happened?
CBS, kindly turn to page 19.
Yes.
Revision application file. Here is
Challenging what order?
challenging order directly to text test before the after remand.
Oh, so it has been remanded.
Remand challenging that valid I came before this honorable court.
Yes.
This honorable court is of the opinion that an interim stay of operation of the impugned order dated such and such will put till disposal of this application. I got it. Page 19, and
Yes.
B.
Yes. In addition to the order passed in the there should
Not
be an
transferred
order
in it.
directing stay of operation of the impugned order, stay of operation till the disposal of this
This
application.
application.
This is pending.
This is pending. Now, my lord, this order has been
Are you
interpreted.
sure this is pending?
Last order I have also annexed. It's not that
All right. Yes.
last order your lordship fine. After that,
19th of February 2024.
yes,
What is the issue? Larger bench?
that inter share and other. That is the only issue.
Entire share. That is there in entire share.
My lord is looking Chanarani for that purpose. But be as it may, my lord, unless it is there, we cannot ask because Chanarani has.
Now what has happened?
Now, Mark, can you consider order dated 27th February 2023 passed by the Honorable Trial Court.
27th of February 2023.
Yes.
You are
Cons-
challenging now.
No. Considering the judgment passed by the Honorable Supreme Court, that 6 months is a stay will operate.
Vacate it.
That has been vacated.
Oh, Mr. Rai, there is a subsequent order.
Subsequently, it cannot be automatically vacated.
Yes. So
After-
produce that.
Everything was produced. Not the matter is pending before this honorable court. These are also been held.
No,
But then my can
order dated 22nd of April.
yes, 27th of March.
22nd of
27th of March. Sorry.
24th of March.
27th February 2023. Well, can you consider the order?
7th of February.
Yes. I got it.
There is no order of 22nd of February.
27th February 2023, order number 76.
Order number 76.
Yes. Just after page 23, 22 after
Yes, yes, I've got. Yes.
the entire order sheet I have.
Oh, show cause as to why the order is and the instance should not be proceeded within. After this, show the subsequent order to the learned trial judge.
Yes, I'm coming. The subsequent orders of the learned trial court I'm coming. Now I'll turn to order number 86 dated 24th March 2025.
86.
86.
Yes.
The court is of the opinion where is the stay of all further proceedings of the trial court.
To show there is a stay order of the Honorable High Court with respect to proceedings in the instant suit.
Yes.
As the instant suit has been. Where is the order of the appellate court? Appellate court means challenging which you have preferred this 2015.
Here, Lordship can kindly consider.
Is here set aside.
Page 17, the ordering portion.
Proceed with the trial.
Direct
is directed to remand the original file and to proceed with the trial in the light of the observations given. Matter is sent back on remand.
Yes.
So that is stayed.
That has been stayed. Now I have annexed all the documents with the court below. Can I turn to?
Mr. Rai, your counterpart has not made any effort to apprise what's the effect of that.
At least I have annexed those applications.
Maybe applications, no submissions, nothing. What is the effect of that?
The court is of the opinion where is the stay of my proceedings? What?
Yes. So you have to apprise what is the effect of an order of remand, stay of the offer.
If the order of remand is not stay of the operation of the order pursuant to which the order of remand was passed, the learned trial court is proceeding. There is no stay so far my proceedings concerned.
This order is under challenge. 24th.
Yes, yes.
Which order is under challenge?
The order is, my lord, 22nd March 2025, April 2025. Yes.
The order dated April 22nd.
22nd.
The order dated April 22. Yes, call the next matter. Huh? Yes, call the next matter.
Item number 13.
Yes, pass over next.
Item number 14.
Lord, I am first.
Yes.
Lord, the order impugned by the order impugned, Lord, the
Caveat is there.
no, Lord.
Yes, what has been done?
39, Lord, the order 39, rule 7, application was filed by the defendant was allowed. And that is the challenge, Lord, before your lordship's court.
Yes. What is wrong in this order?
Lord, the wrong is this, Lord, the
Order that rule 7 for what?
Lord, the for the purpose of Lord, the for the purpose of ascertaining whether there is a Lord, the room under my position, that is the position of the defendant, where from the water connection was given.
This is a dispute with regard to supply of water.
The supply of the water. Lord, he is the defendant. Lord, kindly see. Lord, kindly see one more.
Whose application is for water supply?
Lord, my application that was allowed. My
Show me the application for supply of water.
yes, Lord. That order, Lord, I am showing page.
You are the plaintiff or the defendant?
I am the plaintiff.
Yes. What is the suit for?
Suit for Lord declaration and permanent injunction.
What is the declaration? Is you are a tenant?
No.
So?
Lord, I am the owner. I
Yes.
am owner. The defendant is also the part of the property. He is also the owner.
Yes.
The declaration that I have entitlement to use all the common facilities.
Yes.
And the permanent injunction.
Yes.
And Lord, in that particular suit, Lord, the my water connection was stopped. Lord,
your water connection was stopped.
Yeah, Lord.
Yes.
And Lord, I filed an application under order 39, rule 7 previously. That was commission was done. Commission went there. Commission says yes, the water connection was stopped. Accordingly, 151 application was filed. Lord, the moment 151 application was filed, Lord, the 151 application was allowed. Direction was given for the water connection. Up to this part, no challenge was preferred by the defendant. The moment the water connection was given, the defendant has
water connection has been given.
The moment the water connection has been given, the present defendant has filed the present impugned application under order 39, rule 7, regarding that there was some mistake committed by the commissioner. Those mistake was done due to my my fault on the part, because I did not open the all the rooms which were under possession. If this was done, then the situation was something otherwise, and that is why this application.
So this room was kept under lock and key.
This was under the lock and key, but
it's in your possession.
In my possession.
What's the difficulty? You open, let the commissioner go. There, the commissioner will not find any water supply there.
My lord?
In that room, the commissioner will not find any water supply there.
No.
So what's the difficulty? Let the inspection be done. That will be good for you.
Lord, there is a temporary connection.
All right. So let that be decided.
Lord,
the commissioner will only go and report. Nothing.
Lord, kindly see the observation of the learned judge. Kindly see, Lord, the first page, a middle portion.
Sir, nothing will happen. You have got your supply of water. This room admittedly was not inspected in the earlier commission. So let the commission be held. Nothing will happen. Ashun, this application under Article 227 of the Constitution of India is at the Call the next matter.
Number 15. For the petitioner,
Yes.
the plaintiff, in a suit for the eviction of licensee.
What is the
Plaintiff-
impugned order?
Impugned order, my lord, the matter was fixed for hearing, peremptory hearing, my lord, in by the appellate court. A letter came from some unknown person, I am an interested person. On the basis of that letter, the court, my lord, said that the matter is taken off the hearing list, adjourn the hearing and directed, my lord, the steps on that unknown person without, my lord, any addition of party application, without, my lord, any order that he is added. And there was a direction of this honorable court that the appeal has to be expeditiously disposed of.
Who are you?
I am not the plaintiff,
Respondent
plaintiff
in the appeal.
respondent in the appeal. I am the owner, eviction of licensee. In the appeal, my lord, initially no occupational charge was given. We came to this honorable court. This honorable court said
There is substance in the submission of the learned advocate.
Lord, not November, but is too long, my lord.
September, many
I
matters.
can come back. I can come back, mention the matter, and get it disposed of. I'll serve, my lord, and come back.
Yes.
Kindly make it
Serve,
repeated, my lord.
serve, then I will consider.
Instead of now.
Yes.
Yes, sir. Not- Kindly make it now, September.
Anyone pass over next?
Order number 17.
17, you are appearing. Yes.
Counsel for the petitioner is in annex building. I'm praying for a short passover, Your Honor.
Short passover, how much time?
After lunch.
That's a long passover, not a short passover. Passover, yes, next.
Straight foot.
18 I'm paying for not this week, my lord.
Why?
Why the senior is not present here.
On the prayer of the learned advocate for the petition.
The petition, there is no caveat.
Yes.
Lordship, suit is for I'm for the defendant in the trial court. Suit is for declaration and permanent injunction. I'm for the defendant bank. Expressive powers order in view of the fact that the learned court below has no territorial jurisdiction to entertain the suit even. If your lordship kindly come to the plaintiff.
All right, come at 2 p.m.
Lordship.
Under item number 31 and 32, your lordship was kind enough to fix at 4 p.m. today. But in the list, matter there is 4 p.m. is missing.
31 and 32 টা 4 p.m. করা আছে বলছেন অর্ডার দেখুন।
Yes, yes, in the order sheet is there.
দেখুন তাহলে 4 p.m. করেননি মার্ক কেন?
তার আগে ধরে নেয় ধরে দিন না।
তার আগে ধরলে আমি চলে আসবো। যদি না হয় তাহলে
Since it has not been marked,
if it is
called
taken
up
up earlier, my lord, I will be here. If it is not taken up, then
আরে সে থাকুক, মার্ক করেননি কেন এখানে, সেটা তো বুঝে নেবো।
My lord.
Because some applications are there, that is what
Yes.
you can come back to that.
Yes, yes, I can come. But when your lordship will direct me, I will come. I will come.
তোর সময় কোন আছে? Yes.
Monthly list item number 104.
Lordship, I'm led by Mr. Shottam Mukherjee. His mother-in-law is admitted in hospital, so I'm paying not this week, maybe on Monday. Can it be taken up?
104.
104. For the petitions. Yes.
On the prayer of the learned advocate for the petitioner.
Session, it was your lordship's pleasure that item number 20 would be taken up.
হ্যাঁ ওইটা ডাকলেন না যেটা
Yes.
If your lordship kindly come to the plaint, which would appear at
What is the impugned order?
lordship, impugned order is dismissal of order 7 rule 11 on contest.
What is the ground under order 7 rule 11?
Because the learned court below has no territorial jurisdiction to entertain the suit even. If your lordship, lordship
What is the
kindly,
suit for?
this is why I am beseeching lordship.
What is the suit for?
Declaration and permanent injunction.
Show me the plaint.
Yes, lordship. Kindly come to page number 10 of your lordship's brief. Lordship, kindly come to the plaintiff. Such and such a partnership firm having its office at Jhankar Mode, Barwan Road, Shiliguri. Outside that page 10 of Annex P1, lordship.
Yes.
Kindly come to the address of plaintiff. A partnership firm having its office at Jhankar Mode, Barwan Road, Shiliguri. Outside the territorial jurisdiction of the learned court below. The sole defendants, that is Indian Bank through its manager having jurisdiction, having office at 86/1 BB Ganguly Street, Kolkata 12. I would beseech your lordship to kindly come to the averment at page of my order 7 rule 11 application, which would appear at page number 82 of your lordship's brief. In this particular address, there is no branch of the defendant bank even. I have inquired from my client. Kindly come to order annexure P2, page 82.
Please give me a minute.
Lordship.
Where is your application under order 711?
I'm grateful, Lordship. Can you come to annexure P2, page number 82? Lordship, relevant paragraphs at page number 84, page number 9 on paragraph number 9 onwards.
So your ground is section 34, bar under section 34.
Absolutely. Not only 34, but the Learned Court Bill has no territorial jurisdiction to try and entertain the suit even. And I have also cited before the Learned Court below the judgment passed by the Honorable Apex Court, which is very well-known judgment. 1994 page.
That's on fraud.
Yes.
Have you seen the latest decision of State Bank of India versus Provajan in 2025?
No, Lordship, that has not.
You are on fraud. So that cannot be decided under order 7 rule 11. That is on section 34 of the Securitization Act. That you have not seen.
Lordship, may I come back tomorrow?
Please consider that.
Lordship is fixing the matter on?
Next week. Yes, next.
Item 19, my lord.
Lordship, let the matter be retained in the same position.
Yes.
Item number
I'm grateful,
19.
No, written link banna next week.
Item number 19, my lord.
Yes, what happened? You are not there.
I'm after
It was called on prior to recess, Mr. Rai.
practice. At 1:30, my lord, I am here. This is recorded. I have impression that
Before 1:30.
No.
This matter was taken up at 1:29.
1:20.
His matter was taken up at 1:29. Don't say before 1:30.
1:25, my lord. I am 1:25.
Yes, what do you want?
I want to do this.
Can you not wait till tomorrow? Because some upgraded matters are there.
If it is there, my lord,
Yes.
Lordship, will it be Lordship's pleasure to keep the matter on Monday under the same heading?
Next week I've said. Motion. Yes.
Item number 137.
137. Yes, Mr. Banerjee.
Petitioner, my lord. My suit has been dismissed without deciding any issue under section 10.
It has been dismissed.
Dismissed under section 10 without deciding any issue. Section 10. Section 10 will not be stay of suit.
But Mr. Banerjee,
This is
just
the second suit. This is the second. May
Can
I-
it be?
against that we prefer a review. Review has been dismissed, saying that there is no ground of review. Now, my lord,
Ultimately, you have to challenge the parent order has to be
parent
challenged.
order, my lord, if it is not decision on the issues, it becomes a decree. I have to go to the appellate court. Here, lordship will see what happened. I filed initially a suit.
So what is the miscase for?
Miscase, my lord, review was filed.
Oh, miscase is
Review
review.
is dismissed on the ground that there is no ground for review, which is also erroneous because complete not patent mistake in applying a legal provision, section 10, there is an error apparent on the face of the record. On the face of it, there is no debatable issue that whether the law has been correctly or incorrectly applied. Section 10 suit cannot be dismissed. Court has said under
Oh,
section.
but Mr. Banerjee,
My lord.
the exhibits and other things, deposition, everything considered.
Lordship, kindly see whether any issue has been decided or not.
Maybe it's not
Kindly-
decided.
kindly-
That can be, you can challenge that in appeal.
Kindly see
And,
what is the
if
finding.
Dismissed.
After discussing, kindly come to the last
Mr.
court. My lord.
Banerjee, apparently.
Without, no issue is not
Maybe,
taken up.
maybe.
No issue is taken up for consideration. But is it a decree for appeal? My lord? No appeal.
Has to be.
But
It has to be.
kindly-
Suit is dismissed. Revision is not maintainable.
on technical ground.
Mr. Banerjee, revision is not maintainable.
Against that
the
review was preferred.
final order has been passed. No existence of the suit.
No, against that review was preferred, my lord.
Review dismiss means the parent order has to be challenged. Review dismissal is not an appellable order. You cannot challenge that. So it's the
Revision.
parent order which have to challenge, and that's an appellable
the
one.
finding in the review, my lord, kindly see, my lord, the court has said there's no ground of review. That is why I want to say that I can satisfy your lordship that there was not error apparent in not on fact but on law.
But order 47, rule 5, I think it's a bar.
Kindly,
It's a bar. Rejection cannot be challenged, Mr. Banerjee. And if there is no existence of the suit, how the revision is maintainable? Sorry, order 47, rule 7, not 5.
an order of the court rejecting application shall not be applicable, but an order granting application will be objected.
Yes, granting, because it modifies. Not rejection means you have to challenge the parent one.
Now, my lord, kindly consider, even then, my lord, I have challenged both the orders, the parent order also. Parent order, if
But
your lordship
not
is
revisable. Not revisable. Uh, that ongoing suit.
ongoing suit. Why
And
should
that could have been transferred such and such. So that suit is pending.
that suit is that suit was pending when this order was passed.
Yes.
Then my client was advised not to withdraw that suit, and the review was moved. The previous suit was withdrawn, and so review was moved. That was the wrong advice. That suit should have been pursued. They have not done so. I cannot not improve that. They have withdrawn. But this finding that I have to only amend the previous suit, I cannot make a prayer for recovery of possession in a subsequent suit, is perverse.
If the suit is
And misapplication of the provision. So it's error apparent on the face of the record. Error of law, not error of fact, error of law. Apparently, the section 10 is not permissible. Court has no
the
power.
appeal you can take that ground. You can take that ground. Even interlocutory orders can be challenged in appeal.
Also, you kindly observe that appeal is the proper remedy.
This application under Article
observation.
What? I cannot condone it from here.
No,
Mr.
you're condon that you'll be entitled to take the point of not pendency in a wrong forum. Only one observation. I'll be entitled.
Banerjee, learned advocate appearing for the petitioner submits
Item number 143.
Yes, Mr. Rai. Where is your junior, Mr. Tutiman Banerjee? Pass over next.
Item number 418.
Din. Pass over next.
Item number 469.
This matter is for expeditious disposal of Section 24 Hindu Marriage Act application still pending before 11th Additional District Judge.
This application under Section 24 of the Hindu Marriage Act.
Yes.
This application under Article
It has been
227.
This is my application.
Yes, Mr. Bose.
But the petitioner husband had instituted a divorce proceeding before the learned additional district judge.
Expeditious disposal.
My lord.
What
my
is
lord,
the stage?
The wife who earns double the income of the husband immediately filed an application section 24 seeking interim maintenance. But she is not willing to proceed, delaying the entire matrimonial.
But that has to be disposed of prior to the this application
Yes.
under call the next
Item
matter.
number 481.
Yes. Who is appearing? Sarbananda Sharnal. Mr. Rai, Mr. Sharnal is not your junior. They have mentioned and they do not care to come when the matters are taken up. Pass over next.
Item number 484.
So my application.
Yes.
Suit for declaration and injunction. Declaration that will property A and B are
What is the impugned order?
will refusal to grant injunction will by the appellate court.
Refusal to grant injunction.
By the appellate court. Will in appeal. In
Trial court?
Trial court initially ad interim granted, then will on contest will rejected. Will on the ground that will there is no easement-ary right. Will I say that will there is an easement-ary right over the passage which was conveyed to me will under the deed, which was conveyed to my predecessor in interest will my vendor under his deed, even will his predecessor had it will under the deeds. So all the chain deeds should show that will this passage will is an easement-ary will there is an easement-ary right. Milord, interestingly, in their written objection, Milord, the defendant suggested that yes, this is a common passage, but not for me, for the other Milord plot owners. Milord, that is something Milord absurd. If my Lord kindly just have a look at the written objection once.
There's a specific finding. You are the plaintiff.
Yes.
There's a specific finding that you have a specific entrance on the municipal road, Mr. Bennett.
Correct. Milord, I am not
So,
saying that
if there's an alternative road,
Milord, there are
this-
two kinds of easements. One is easement of necessity. One is Milord easement which Milord runs with the land.
Yes.
As a covenant to running with the land. Milord, I say this might not be Milord an
serve,
easement of
serve upon them,
I'll
let
serve
them
it.
come.
You should stay.
Or I can direct the miscellaneous appeal to be heard out. I think that's better.
Let us try our hand before your
Because,
lordship.
because it's pending since 2024. I do not know how long it will be kept.
Milord,
Or in
if
the
without any
meantime,
observation, Milord, the matter is
20
given.
is fixed for hearing the miscellaneous appeal.
Let
That
me
is-
have and come back and try my hand, Milord, once before your lordship, once.
What happened, Mr. Banerjee, if some observation is there, then miscellaneous
The
appeal
observation
goes.
should be in my favor, Milord, I'm sure.
That miscellaneous appeal goes, or I can direct, that will be
I
expedited.
have such a good
Otherwise,
case.
miscellaneous appeal will be kept pending. This will also be kept pending here. You can try your luck after the appeal is, if it is in your favor, it is in your favor.
Kindly allow me to try my luck here once, because I have a wonderful case on merits.
Yes, that is why I am directing you to make out that case in the miscellaneous
Milord,
appeal.
we'll do that.
Because it's only the ad interim prayer which was refused. Miscellaneous appeal at the
Now,
final
Milord,
hearing stage, you
what
can
he has
succeed.
done, Milord, he has installed, Milord, a gate on the common passage, and Milord has put a padlock. Milord, unlike the padlock is open, Milord, I have, Milord, two entrances. One, Milord, directly from the, Milord, main road. One is, Milord, through the passage, Milord, through another entry. Milord, if one entry is blocked, Milord knows, Milord, this Bengali,
Sir,
Milord,
Banerjee, if there's an alternative passage there,
easement of necessity,
so
my Lord is thinking
that
of.
then it goes, easement of necessity
Milord,
goes
I am
there.
pleading easement of necessity. I am saying, Milord, this runs with the land. And that is, Milord, what is admitted, Milord, in the written
It's a
statement, in the
different
written
thing
objection.
altogether. Show me your deed of conveyance.
Yes, Milord. My deeds of conveyance are at, Milord,
This
page,
right has been mentioned there.
yes,
Show me that.
page 70,
Page.
70, it starts. Milord, there are two deeds in my favor.
You have
70,
purchased by two deeds.
yes, Milord, plaintiff number 1 purchased under a deed, and plaintiff numbers 1 and 2 together purchased, Milord, another
Which
plot.
deed records this right? Show me one of them.
70, Milord, it starts. Kindly turn to page 75. Milord, last but one paragraph, first line, right hand side.
Right hand side.
Yes, Milord, page 75, my Lord, will kindly.
Yes.
Milord, the third paragraph, after the continuing paragraph, Milord, one paragraph starts with or howsoever.
Yes. Then
Milord,
together with.
yes, on the right hand side. When easements, Milord, is indicated.
No. Show me that you have a right. Where is the sketch map in your deed?
Yes, Milord. Kindly, Milord, turn to page, Milord, 85.
Yes.
Milord, the common passage on the left hand side
Yes.
is, Milord, the common passage.
That is the suit property.
Oh, Milord, I'm sorry. Milord, the common passage, Milord, on the, Milord, at the bottom, down below, Milord, the line.
Southern side.
Yes, southern. It's not, Milord, southern side.
6
It would
feet
be
wide
eastern
common
side.
passage.
It would be, Milord, eastern side, yes. The north is, Milord, on the right hand, going by this map.
Yes.
So, Milord, on the eastern side, Milord, at the bottom.
Yes.
6 feet wide common passage. Milord, this is, Milord, the
And
passage.
which is the municipal road? That is 12 feet wide common passage.
Yes, Milord, that's, Milord, municipal road.
And where it has been stated that you have a right over this 6 feet wide common passage in your deed, show me.
Yes, Milord, in my deed it says that, Milord, is inventory, right?
That's vague.
No, Milord.
Not with regard to this property.
Milord, allow me, Milord, to make out my case.
Yes.
Milord, now, Milord, my vendor's deed is also there. Milord, since I say this runs with the land,
Show me your vendor's deed.
kindly take, Milord.
Your vendor was having, and you have purchased when? You
Milord,
have purchased this property when?
Milord, I purchased 26 February 2018 one, and Milord, the other one 21st October 2021.
So the earliest is 2018.
28.
Show me your vendor's deed.
Yes, Milord, page 58. Kindly turn to page 63, Milord, there. Milord, there is a schedule, Milord, topshil. Kindly take the second paragraph of the topshil. My ukto jomite danga jomi.
Where have you?
Milord, page 63, running page 63.
63, yes.
My Lord will kindly get the schedule there.
Yes.
Second paragraph of the schedule.
Yes.
2016 নম্বর দাগে আমার খরিদা নকশায় লাল রেখা দ্বারা চিহ্নিত কম বেশি 2 কাঠা জমি, this is Milord the land which is subsequently transferred to me. জমি মায় উক্ত জমিতে যাতায়াতের জন্য দক্ষিণ দিকস্থ 12 ফুট প্যাসেজের সমস্ত
Yes.
বর্তসাত্রা।
So this is the municipal road.
Milord,
So this is the right of your easement. This is the right of your access
Milord,
in the deed. Yes, Mr. Banerjee, anything more?
No, no,
This,
Milord, I'm sure, Milord, my
You can, I am directing the miscellaneous.
Milord, I
appeal.
think, Milord, my learned junior is a little mistaken. Milord, I was correct in saying that, Milord, on the left hand side, Milord, that is, Milord, the common passage. Over
Show me
which
your
I'm
plaint.
keeping inventory.
Show me your plaint.
Yes. And Milord, before I show your lordship the
Or
plaint,
Mr. Banerjee, at this stage, I can give you liberty. I am directing the
Milord, I'm
miscellaneous.
still
appeal.
breathing before your lordship, Milord, let me take a chance.
All right.
Milord, there is.
Then it will be on merits. After that, no going back to the appellate court.
Milord, I have, Milord, my vendor's predecessors did also. Milord, kind just
Your deed and your vendor's deed does not recognize that.
Milord,
Prima facie.
Milord,
If
may I show-
over that 6 feet,
Yes.
it's
Milord,
over 12 feet.
Milord,
Now show me that you have claimed right over this 12
yes,
feet.
but before I show that, Milord, kindly just have a look at one line, Milord, of my vendor's predecessors did.
I will come to that
Very well,
thereafter.
very well. Milord, my plaint is at, Milord, page 13. Kindly turn to Schedule C, Milord, page 19.
It's the 8 feet width
8 feet, Milord, width.
and 73.1 feet length.
Yes.
Show me from your deed, which is that.
Milord, on the north, 8 feet wide common passage.
Your
On
deed
the
is
south.
sketch map is
Milord,
at
kindly
page
tally, Milord, page 19 with page 85.
85. Yes.
On the north, 8 feet wide common passage on the south municipal road. Yes, Milord, I was correct. Milord, if I say on the south municipal road, Milord, this 12 feet is municipal road, so common to the south of the common passage is the municipal. So, Milord, I was right. Bhul bolish কেন?
No. I could not get you. Your this is all that piece and
My
parcel
lord,
of
you
a
kindly
common
come to page
passage measuring about 8 feet
Milord,
in
kindly
width,
take page 90. My lord is at page
73.1.
90. My lord is at page 90. Milord,
What is 73.1? Yes, I am at 19.
yes.
So you have claimed easement right in respect
Over
of it.
C schedule property.
Yes.
So, Milord,
Show me the C schedule property.
yes. Milord, kindly see schedule C.
Yes.
To the property described in schedule C, Milord, to the south of that property, Milord, municipal road runs.
On the north.
On the north, 8 feet wide common passage. On the
North
south,
is-
municipal road.
On the north is, on the south is municipal road. On the east is B schedule property. On the west is A schedule property.
Yes.
What is so A schedule property? So, and you are claiming
I am claiming
country right over C.
C, which is ending on the south, Milord, at the municipal road. Milord, the southmost point of the common passage is, Milord, the municipal road. So, Milord, this is the passage. And Milord, on both sides of it, Milord, I have property.
Schedule C from the butted and bounded, it does not make any sense. Schedule C is the passage.
Yes.
So what is that passage? Show me from this 85.
Correct.
What is C schedule?
Milord, to the passage, Milord, as is described in Milord schedule C, to the south of that passage is municipal road going by the schedule.
Yes.
Now,
To the
Milord,
south of that passage.
correct.
So what is according to you is C schedule property.
Correct.
Please
Now,
show
my
me
lord
from
is at
85.
page 85.
Is 85?
Milord, south is on the left hand side at page
Show me
85.
which one you please indicate page 85. Which one is the schedule C?
Milord,
there are three writings. One is only common passage.
Correct.
Another is 6 feet wide common passage.
Correct.
Another is 12 feet wide common passage.
Right.
Which according to you is the C schedule property.
Milord, this is at the bottom.
So this is 6 feet wide common passage.
Correct.
So if this is 6 feet wide common passage, on its north, Mr. Banerjee is the property. It's not the common passage because there is a property. On the south is also another property. Cannot be the municipal.
Milord,
That
on
cannot
the
be the
east-
schedule C. That is why.
No. Milord, on the east of this common passage, there is, Milord, B schedule
Mr.
property.
Banerjee, all are to be tallied.
Correct.
If 6 feet wide passage is the C schedule property, so on the north is the property of the defendant.
My lord, can you grant me a moment's time? আমার এটা তো A, এটা কোনটা? My lord, I have purchased two lands. My lord, one is this land area 2 katha. My lord, under the other deed, my lord, I purchased, my lord, the land which is to the east of this 6 feet wide common passage. So on
east of this, yes.
Well, so my lord, below the 6 feet wide common passage in this page, my lord, I purchased the other land.
That is Hena Chatterjee.
Yes.
That is Hena Chatterjee.
Yes.
So these are the two properties.
So,
So what is the common passage? Is the 6 feet wide
which
common
is, my
passage.
lord, running between my two plots.
Yes. Yes, but show me that in the deed,
Yes, my lord.
what has been stated
My lord,
in the deed.
south it matches. On the south it
Please
matches.
come to your deed. Please
Page
kindly
19.
come to your deed.
My lord, very good. My lord, I have two deeds. One is at page 70.
Oh no, Mr. Banerjee, north is in this direction.
North
North
is
is in this
on
direction.
the right hand side.
On the right hand side,
Right.
this direction.
So, my lord,
So
left hand side
southeast
is south.
this.
So, my lord, left hand side is south.
Yes, left hand side is south.
Correct. So, my lord, to the south of the common passage, my lord is getting the municipal road, matching with page 19. That's what, my lord, I was trying to impress upon your lordship.
On the north.
Unlike other maps, here, my lord, the north is not upwards. North is, my lord, rightwards.
Yes, on the
So,
north is the 8 feet common passage.
So, it's
No.
matching.
No,
Yes.
it's not matching.
It's
85, 6 feet wide common passage if the C schedule property. So on the
Yes.
north is VL of others. There is no common passage on the
Let
north.
us take the south boundary first. My lord, the south
Correct.
boundary is municipal road.
Sir, petitioner is directed to serve a copy of this appeal.
To bring on
As
Is for
12 weeks.
12 weeks. My lord, I'm for the petitioner, my lord.
Yes.
My lord, this petition, the predecessor in interest of this petitioner lordship was the sole defendant lordship of a suit wherein the plaintiff lordship are asked for
what are you paying for?
lordship. I am paying for that. My 7.1 and 7.2 application was refused, lordship, on the ground, lordship, rejected on the two technical ground, that lordship. Lordship, kindly see the certified copy. Lordship, the order dated 11/9/23, lordship. Lordship, 7.1 of the Premises Tenancy Act was refused, lordship, that it is not notarized. And 7.2, the name is not matching. Lordship, what happened on that very day when the application was filed, lordship, on that date, lordship, the sole defendant died. Lordship, I have annexed the death certificate, lordship. And thereafter, on matter was taken up on that day and date was fixed on the next date was fixed.
What is your application under section 7.1 and 7.2?
Lordship, 7.1 for it is for the eviction decree, lordship. Lordship,
7.1, 7.2 application have you annexed?
7.1 and
You have not annexed.
no, lordship.
So what's wrong in the order?
Lordship,
What is the wrong in the order? Where is the application?
application is not annexed, lordship.
The learned advocate appearing for the petitioner prays for time to produce the copy of the application under section 7.
Lordship. Thereafter, when they
Oh,
could not
no,
trace
Mr.
out.
Banerjee, this challan was passed
but
Passed.
on 30th of August.
yes,
Yes.
When did you deposit?
it was not
On
handed over
November
to me.
9th.
I filed the petition.
Where is that application? You have stated that it was
I have
not.
stated that it was not given to me, so I again went to the court. The court said it is misplaced, so I again passed another challan and deposited.
When? That is when?
It was in November, just opening after opening of the court.
November 9th.
No, when the order under section 7.2 was
When it
passed.
was passed on
August 28, 2022.
Show me that order.
7 to
Order number 14, Your Lord.
28 July 22. 28
Yes.
July. Page
So
order
this,
number
by
14,
this order,
my
you
lord.
are directed to deposit within a month.
By 30th of August.
By 30th of August.
On 30th
So
of
by
August,
30th of August, you have approached the court. That was passed.
challan was passed.
Now, according to you,
This was
that
not
it was misplaced.
misplaced.
And you have deposited. So did you pay for extension?
Yes, I filed another challan saying that application was made.
Mr. Banerjee, there are two things. So this, by this order, 28th of July 2022, disposed of by directed to deposit to the plaintiff by the next date. So that was by 30th of August 2022. And you waited till 30th of August 2022.
On that day it was
Yes, you waited till 30th of August. On the last day, the challan was passed.
passed but not handed over to me.
When it was not handed over, show me your application.
There is no application. Your
Lord,
Lord. In my 7.3 objection, they say.
On reopening, my lord, I filed another challan, my lord. I another application for challan which was passed.
What was the period of the vacation?
Vacation 1 month, my lord. So
From which date to what date?
7 plus 7 2, my lord. 1 month and 2 months. 3 months can be.
That's not automatic, Mr. Banerjee. That's not automatic. You have to pay for extension. Second proviso is subject to if you pay for that. Otherwise, it's
Now,
not
if-
automatic.
If not the challan is passed and not handed over to me, no, it is not.
Only that's yours, Mr. Banerjee, accepted. Even if it is not handed over to you, you could have applied for extension. What prevented you from applying for extension stating those facts?
That application was not there.
Then, so ipso facto that cannot be extended. And where is your application stating these reasons?
7C, my lord, written
Objection.
objection. Written objection I have stated.
Written objection to the
7C.
7.3.
7C I have stated.
When 7.3 was filed?
7.3 was filed on 2024, Your Lordship. July
So,
22nd,
so
2024.
prior to that, when you deposited, so without filing any application for extension, how could you deposit on that date?
The court passed it and I deposited, my lord. Because court allowed it because the previous one was misplaced on record. It was on record.
Show me that order that
It is
court
on-
allowed you. Where is that?
এটা কোথায় পরে যে পাস করলো সেটা কোথায় এটা তো আগেরটা তার পরেরটা নভেম্বরটা তো নভেম্বরটা বার কর নভেম্বরটা কোথায় আছে কি নভেম্বরটা তো আছে কি তোর কাছে May I come back with that order, my lord?
Right.
Because it was
The court has recorded that you have not failed to show any petition filed to inform that challan was misplaced. Only in their objection you are trying to.
order
Sir,
sheet
please.
itself records, my lord,
Need-
that page 21, my lord. Kindly come to paragraph 7 at page 22, my lord.
Yes.
In this connection, the defendant submits that just after passing of the said challan, 28 July, the defendant at once filed court challan for the sum of 407 before this court. But when the advocate's clerk went to search for passing of the said challan, the same was missing from the court office. As per direction of the bench clerk, the said clerk visited again and again to the court office for getting the said challan. At last, the learned advocate of the defendant filed a fresh challan as per prior permission of learned court. Now, after passing of the said challan, the same has been deposited to bank.
That is Mr. Banerjee. You have asked the court has passed that. That's not condonation or extension. Asun, this application under Article 2.
Gratefully urged.
Pass over next.
Item number 664,
Pass over.
item number 679.
679. Yes, yes, Mr. Gosal.
That is, it has an earlier order of Justice Vishnu Bashu. I agree with some instruction. By this time, as there is short direction was there, no stay was there. The High Court is proceeding, even if my suit is going to be dismissed tomorrow.
So who is for the other side?
Not appearing in spite of notice.
But Mr. Gosal, today you have taken a resolution. What can be done?
Neither they are appearing in the trial court. My instruction is that.
Mr. Gosal, today you have taken a resolution. No order in the absence of any of
This honorable court. But today is also the date with the court below. No, nothing, no steps has been taken. But kindly then.
What is the impugned order?
Order is that order 11 to 102 rejected. The suit for eviction. Plaintiff is the tenant.
Suit has abated.
That is
in respect of the dependent number 3.
Before there is no application to that effect order 22. Petition was order 20, order 19, 11, or 1 and 2. That has been rejected. I marked that. I marked that. But 2 parts are there. My petition was under order 11, 1 and 2. That has been rejected.
But abatement, Mr. Gosal, even without an application, that can be recorded.
That is
the date intimation comes automatic. So automatic, so there is no difficulty in recording this. So you can take out an application for setting aside of that. Abatement.
That kindly see even this the pending High Court application is there. You got to the notice of the lateral court. So kindly protect me otherwise. Some protection may be given that till this is done, that should not be proceeded with.
All right, I'm making it not today because today there's a resolution. I cannot take it up Otherwise, I could have taken up.
And it will
Please
be
take back the affidavit service. Yes, call the next matter.
the next week.
It will appear on the next day.
And whether my lord can record that there is a complaint with my lord's direction.
On the next day, because on the next date I will record that. No problem. Keep it with you.
Next week, but next week.
Let me see. I will fix this.
The trial court will again prevent him. Everything is being dismissed. Waited. Everything is being done.
All right. At the order record করে দিন. Mr. Ghoshal landed at
Hearing on behalf of the petitioner, my lord, this is the expeditious hearing applications under Article 227. This is a match.
expeditious hearing of what?
The match shoot that is pending in additional district sessions judge.
You are the husband or the wife?
I am the wife petitioner. And this is the affidavits of service. I have also served the copy of the opposite party.
Why have you served? There was no direction to serve.
No, not directions.
Then why have you served? This application under Article 2.
In this matter, Mr. Shantanu Kumar Mitchell is appearing for the opposite party lordship.
Okay.
Lordship, because of high fever, he is late. Lordship, I am only ready for not today.
What is this matter, Mr. Ghosh?
Water supply has been disconnected by the landlord opposite party.
All right. Not today, next.
Grateful lordship.
Passover next. Passover. Passover. You are appearing.
I am appearing for the opposite parties.
Passover
Other
next.
notice.
1090, my lord, I appear for the petitioner. No caveat in this matter. Lordship had placed the matter a couple of days. This is regarding the West Bengal Cooperative Societies Act. Lordship had directed me to bring the statute That day I was appearing virtually.
What is the impugned order?
My lord, by the impugned order, the tribunal has sat on appeal in an order which has been challenged. That is not an appealable order under the statute. That is my main contention here, besides the points on merit. May I just indicate the facts, my lord?
Show me the impugned order.
Yes, lordship. Right at the back of the petition. Kindly sees from page 2, internal page 2 onwards. The first line itself states this is an appeal filed by one Alok Singh against the state of West Bengal, the registrar of the Cooperative Society, Bengal Shoroshi Cooperative Housing Society, which is me, my client, the secretary, Bengal Shoroshi Cooperative Society, as the appellant was aggrieved with the judgment and award passed on 25th of October 2017. My first contention is this is not a judgment and award.
Show me that 25th of
Kindly
October
comes to page
2017.
146, my lord.
Page 146.
Yes, my lord. A direction was given by this honorable court in writ jurisdiction to consider a representation of the petitioner. That was considered and reasoned order was passed. May I just place the first two paragraphs?
Show me the act.
Yes, lord. My lord, I've flag marked it for my lord's convenience. My lord will kindly take up the orange flag mark, that is section 102. And my lord may just indicate one thing before lordship goes through the provisions of the statute. Kindly sees page 149.
Please give me a minute.
Yes. Kindly sees flag
102.
section 102. That is, whenever a dispute arises between the members, between the member and the society, it has to be first lodged with the registrar, who will then send it to the board of arbitrators. 102 and 103 conjointly may be read, my lord.
Where is the award defined?
My lord will first kindly take up section 147 once.
147 award has been defined.
No, that is appealable orders. My lord will only take up that
No,
one.
award where it has been
Yes.
defined.
Award. 147, my lord, it has defined which orders may be challenged in appeal before the tribunal. No other orders, only those. An appeal shall lie from an order shown in column 2 to the authority shown in column 4 within a period shown in column 5 of the third schedule of the Act. The third schedule is also marked with a flag, the green flag.
Show me the representation which was directed to be considered.
That has not been made a part of the appeal that was taken out by the opposite party. It is only indicated here. Lordship will kindly see page 146. There
What was the dispute in the representation?
Lordship, page 68, my lord will take up. Page 68. This was the information they had sought for. I'm sorry. The dispute was that the opposite party had bought a flat at the housing society, and he, out of his own volition, had paid 50,000 rupees as voluntary contribution to the development in 2015. 1 year later, he turned around and he said that no, this was under coercion. I did not want to pay it, they made me pay it. And he filed a representation before the registrar. Kindly see page 76.
Who is Alok Singh?
Alok Singh has purchased a flat. He is the opposite party. He has.
You are the society.
I am the society and the secretary.
So according to you, since it was not an award,
It was not an award, and liberty was given to take recourse to section 102, and there's a specified rule as to how they have to file a complaint. Court fee has to be paid whenever there is a recovery of money involved over there. Nothing has been done. This was simply a
what is on technicality?
consideration.
What is on merit?
Yes.
What is on merit?
Merit, Lordship, there's nothing on record to show that 50,000 rupees was taken by force. The opposite party himself has written a letter. I will take my lord to that page. Kindly see page
So let
64.
it serve a copy upon them.
Let there be a stay on operation of the.
You have to secure that amount.
This is a nullity, my lord. That is my humble
Please
submission.
secure that amount. You need not pay to them. Secure that amount, deposit it before the Registrar General of this court. I will pass an order of stay. Otherwise,
This
only
is
sir.
the tribunal has assumed jurisdiction, my
Only.
lord. There's no jurisdiction given. Inherent lack of
You are not
jurisdiction.
paying to them. Please deposit to money decree. Please secure that amount, deposit that. It will be invested in deposits.
Lordship will then pass such direction.
One stay or you can serve and come. Choice is yours. One stay you have to.
To take instructions. I have to take instructions, Lordship.
Petitioner is directed to serve a copy of this application. Yes. Pass over next.
For the petition. In this matter, my lord, I have filed an application under section 151 for my lord the repairing.
There is no caveat.
No, my lord, there is no caveat. But we have served, my lord.
Then it cannot be taken up. How can it be taken up then? If you have served, today you have a resolution.
My lord, previously, my lord, the application, copy of the application has been served, my lord.
Sir, I appreciate that, but today you have taken a resolution, no adverse order in the presence of the others, in the absence of any of the sides.
Some protection is because, my lord,
Not today, next.
repairing is not possible. Can you fix the date, my lord? Kindly, my lord.
1140.
1141.
1140.
Yes, yes, I will consider this. Yes, 1141, who is appearing?
1140.
1140, yes.
I appear for the petition. No caveat, my lord. There is no caveat.
Yes.
Revisional application arising out of an order, my lord, passed in rejecting the application under order 7/2011. Or the stand taken, the grounds taken, my lord, the plaintiff then, my lord, is a trust.
This matter, lordship, we appear
According an applicant.
we have been instructed to appear on behalf of the judge. No caveat has been filed.
Please serve him a copy. Petitioner is directed to serve a copy of this application.
1141, Your Lordship, I'm led by Mr. Chaudhary managing this matter. This is a matter for expeditious disposal of a suit where I am the defendant. I filed a counterclaim, my lord. Presently, the suit is at the stage of evidence of the plaintiff. It's a very old matter, Your Honor. Your Lordship, it's a very old matter.
This application under Article 227 of the Constitution peremptory hearing. Yes,
No, Your
next.
Lordship, the evidence of plaintiff has started, Your Lordship. It was filed.
I've said expeditious without arguing.
1181 minute, I'm for the petitioner minute. This is for extension of interim order, minute. But I have soft copy upon the,
Extension of interim order.
my lord. I have mentioned
When
as
this interim order expired?
it will expire on last date of this month, my lord.
Last date of this month.
My lord. The interim order passed on 16th of July 2025. Copy I have already served.
Or list this matter under the heading extension of interim order. Pass over next. Pass over. Pass over.
I'm for the opposite party in 1203. My lord, there is my vacating application is there on record. My lord, it is a order.
Here it cannot be taken up today. Yes, next.
127 to my lord, other side is there since not appearing, not to.
Not today, next. Not today, next.
I'm for the petitioner. Although I have served the copy upon the.
Not today, next. Not today. Not today.
Lordship, I'm for the petition. This is for the fifth time that this matter has been taken up, but due to no adverse, this matter is not being.
Not today, next.
Lordship, expeditious hearing, 4 lakhs is due as alimony pendently, right, Lordship?
Expeditious hearing, then.
Yeah, but no, other side has been served. Direction was given.
Then not today, next.
Tomorrow daily list, if it's keeping at the top.
1-3. Not today, next. Not today.
Your Lordship, I am appearing for the petitioner being laid by Parthaputing Roy.
Yes. Is here. Opposite party is there.
Yes, Your Lordship, copy served.
Copy served. Not today, next.
I'm for the petitioner.
Yes, copy served.
On a copy served, my lord. And
not today, next.
Okay. Achha.
Yes, call the list for us.
I pay for the opposite party.
Yes.
My submission is on the last date. I could not complete my submission. Madam.
Where is Mr. Banerjee? Then how can it be taken up today? Ashun, none appears for the
Lordship,
Yes.
Your Lordship passed an order, Lordship. 7.1 and 7.2 application is already there, Lordship. If
All right, next day, yes.
Lordship, if your
What has been done?
Lordship, 7.1, 7.2 application is already there, Lordship. Admittedly, the both and the what have been detected by the land.
564, what order I have passed?
Lordship, Your Lordship passed that 7.1 and 7.2 application should be bring.
564 টা not today করে রেখে দিন। Yes, next.
Lordship, one thing, one prayer, Lordship. If your Lordship kindly allow me to serve and come back. Otherwise, 7.3.
Sir, this is not a matter of right.
Lordship, no, Lordship.
I have consider, yes, please.
One
I
prayer,
find it necessary then.
Lordship,
Service
one
is-
prayer as Lordship, the 7.3 application would be filed and my defense will be stuck down. Lordship, kindly see there is no fault on my part. I became puzzled on that moment and I couldn't.
All right, I am making it not today, madam. Yes. 564 টা not today করে দিন। Yes.
Preemption fixed matter, my lord. Preemption fixed matter,
Which item?
my lord. Item number 3, my lord.
Item number 3. Yes. Item number 3. You are not present, madam. That is why.
My lord.
Yes. Where is Mr. Banerjee?
Mr. Banerjee is on the Bangalore High Court, my lord. Bangalore High Court. May I make my submission, my lord? My lord, it's their time.
I want to put some questions to Mr. Banerjee before she starts. Yes, madam, you are here. Please take me to the application under section 13. The application,
Section
surface application filed by you. What were the points taken by you?
Was not taken, that's it. It would appear.
You have two accounts, two loan facilities.
Yes, ma'am. Yes.
You have two loan facilities. One is cash credit and another is working capital loan. Do you have the copy of the statement of the working capital loan?
The statement which was shown on the last date, my lord.
Madam, take your seat. Yes. That is cash credit.
My lord, that was not even cascade. That was ECGL, my lord, emergency credit line. That amount has been paid and has been closed. But the main account in which this proceeding has been initiated, that is still.
Yes, yes. Madam, are you ready?
Oh, my lord.
You are not ready.
Oh, yeah.
An accommodation has been paid for on the ground of Mr. Banerjee Lanet.
The 100, Lord, the expeditious disposal of the injunction application.
Please wait. There are some fixed matters are there in the daily list also.
100 is also fixed at 100 to fixed.
100 টা কোথায়? 100 আছে তো। Item number 100.
এটাই।
এটাই তো 100 হলো না।
হ্যাঁ,
100 এর টাকা পেয়েছে।
ওটাই 100।
কোনটা রাখলি? 100 এর টাকা 100 এর পাই।
ওটাই 100 তো? Lord, injunction application ready for hearing.
Item number 100.
My lord. Lord, next date is September, middle of the September, Lord, of this year. Lord, the
Application under Article 227 of the Constitution of
Your Lordship, I'm for the opposite party.
opposite party. Not today. Next.
Obliged.
Not today. Next. You are appearing. Petitioner. Any caveat?
Only early hearing in respect of the declaration suit. It is since pending since 2022.
Suit.
Yes, my lord.
What is the stage of the suit?
Suit, my lord, only, Lord, I have annexed all the order sheet excepting last order. I have only a website copy.
Injunction application?
Yes, only it has been time to time, it has been extended.
Injunction application is still pending.
Yes.
This application under Article 227 of the Constitution of India.
Any time.
219.
Take it.
Not today. Next. Yes, who is appearing?
Mr. Mohendra Gupta was appearing for the petitioner, my lord.
Not today. Next.
But item number 264, my lord, I am appearing for the opposite party number 3 and 4.
My lord, I'm appearing for opposite party number 5, 6, and 7.
Who is for the petitioner? Not today. Next.
My lord, I would just like to indicate, my lord, the petitioner number 6 who's impleaded, he's no more, he's passed away recently, my lord.
Petitioner number 6.
The opposite party number 6, my lord. So I believe it needs to be substituted, my lord.
264 file touch din. What is the name of the opposite party number 6?
Rajiv Ghoshal, my lord. This is his death certificate, my lord.
When he passed away. You did not file that. Yes.
May 11, 2025, my lord.
May 11, 2025, my lord. 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 11, 2025, When this matter is called on for hearing, the
My lord, item number 1090. My lord, I have sought for
number
instruction.
350. Yes, who is appearing? পাসওয়ার্ড করে রাখুন, ওটাতে অ্যাপ্লিকেশন দেখাবে তখন।
My lord, item number 1090, I sought for instruction, lordship. My lord, if I beseech my lord to grant us to pay 60% of the amount.
So if you are not 60%, the entire amount. If you take instructions, take out an application, I'll be considered.
My lord, TP
Yes.
obliged.
হ্যাঁ, রাখুন না, দেখে দিন, তো হয়ে গেল।
My lord, may I be permitted to mention a passed over matter, item number 70?
Yes.
Item number 7.
Item number 17.
Yes, yes.
For the and for the opposite party, that the
I could keep my words.
29.
1 minute still left.
No, আমার খুলতে হবে না, খুলতে হবে। I did not open, my lord. My lord, I had a detailed talk with my client. My lord, I don't want to proceed with the
Civil division application.
civil division application. 3646, my lord, I don't want to proceed. And so far, যেটা নতুন করলাম যেটা। And so far, the another matter is concerned, my lord, against the section 47. My lord, I must be very candid, my lord. But today I have been briefed in this matter. I like to have
both the matters are appearing today.
Yes.
as per
both
your
are-
lordship's direction,
As per your lordship direction.
my learned senior friend wants to, my lord, not press, my lord, the 2646 out.
Yes.
That is, my lord, challenging the 208 application, allowing of
208
208.
application, my lord, and the police have. So, my lord, that I don't want to proceed with this. Your
আচ্ছা দিন, ফাইলটা দিন।
2646.
What is the item number?
31,
31.
32.
31 and 32.
31 and 42.
32. 32.
32.
Consecutive.
Oh, with.
এটা না এটা কত নম্বর আইটেম? So item number 31, my lord, I don't want to
Don't want to proceed.
Yes.
31. Two 646, you don't want to
My
press.
lord, my lord.
Mr. Pan, learned advocate, appearing for the petitioner on instruction submits that
with Mr. Pan, my lord, since my learned senior has a difficulty, my lord, I cannot stand in the way. If
Mr. Pan, learned advocate, appealing yes.
From the
Please,
Delhi
please,
list.
Hearing for the petitioner. I have filed this matter for expeditious hearing. The matter is pending before the learned court since 2017, Lordship. The incident occurred on 2011, in which the petitioner grandmother died and he was physically became disabled. In 2017, he filed a compensation case under section
Application,
166
you are the
of.
claimant, you are the claimant.
Yes, yes, Lord.
This application under Article 227 of the Constitution of India.
The Lordship Expeditious application kindly turns to page 48, my lord. Second time we have approached this honorable court, my lord. The earlier direction was passed on 29th of April 2024,
page
48, your lordship. And my lord, within a period of 4 months, direction was given, my lord, to dispose of my order 40 rule 1. Considering the urgency, I am the widow. My lord, till now, my lord, 48, your lordship, 48. After a span of almost 16 months, my lord, we are still unable to get that application heard because of the defendants, if I may put it in this manner. They don't appear. Sometimes they file orders in Rule 11, that gets dismissed. Then they file an adjournment application every time now and then. It's going on, my lord, for the last 16 months. And my lord, I am a widow, my lord, seeking maintenance partition suit. Some of the properties of the joint family property are being rented out. I'm seeking maintenance.
This application under Article 227 of the Constitution None appears for the petitioner at the time of call. No accommodation has been. Next. 24 টা তো সকালবেলা অর্ডার আচ্ছা এটা 5টা বার ছিল বলছিলাম 17 টা ডাকুন
Lordship, we are appearing on behalf of the petitioner. The petitioner is a widow and she has been ousted from the property. We want an expeditious.
You can adjust the height of.
We want an expeditious hearing for the title suit pending before the second senior division in
What
Balashat.
suit for?
It is a suit for partition, declaration, and permanent injunction. The suit is at the stage of preliminary hearing, Your Lordship. So we are praying for an expeditious hearing. The petitioner is a widow and she is the father parental home, and they cannot allow allow her to live there for a long time because there's lack of space, and she has to move out from the very soon, and that is why she has to take a rented accommodation, and she cannot afford that. So after 2021, when her husband died, she was ousted by the opposite parties. So she filed the title suit at Barashat, and it has been still pending there.
This application under Article 227 of the Constitution of India. Call the next matter.
Grateful, Your Lordship.
And for the opposite party. 25 and 26, Lordship will kindly recollect. One is for where one, the suit.
Where is Mr. Tanmoy Mukherjee? He was here.
Today, my lord, I cannot. Lordship only asked for how many questions they will be asking. How many questions they will be asking, that was the only instruction they have to.
Pass over. Next. Pass over. Pass over. Pass over.
But Your Lordship, this is my application. This relates to expeditious disposal. Lordship, last date it was taken since the title suits it's before the Baripur court. So Lordship wanted to know who is the learned advocate there. Mr. A. Khalikuch Jamal is appearing for the defendant opposite party, and for plaintiff Mr. Dulal Mukherjee is appearing. The nature of the suit is for eviction suit, and the application pending there is 7-2 application is pending.
ফাইলটা কোথায়?
Lordship, kindly peruse my paragraph 8 and 9. There was earlier also petitioner moved one revision application, and in which Honorable Court was pleased to dispose the application by within a period of 2 months. Despite that order, the learned court below has not taken positive step. The suit is since from 2012, and the application is pending since 2014. My paragraph 9, Lordship.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction. Not today, next. Not today, next. Not today. Not today. Not today.
My lord,
You are appearing.
Mr. Deepan Kundi is appearing on this matter. Kindly give me a short passover, madam.
Pass over next. Pass over next. Pass over. 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 Pass over.
Fifty-eight. So pass over.
58.
Pass over. Pass over.
Yes, Mr. Pan.
Well, this is an application, my lord, filed by the state.
Application
It-
filed by the state.
State. My lord, I filed an application for contempt, which is pending before your lordship. My lord, I have mentioned the matter. Now, by an order dated, your lordship, dated, my lord, 22nd of August 2024, directed them to pay the compensation upon initiating a fresh proceeding under the Right to Fair Compensation Act 2013.
What is their application for?
This is an application for my lord, modification of your lordship order.
Yes.
My lord, modification.
Initiating a proceeding of direct purchase policy.
Yes, my lord.
And to pay compensation.
And
Yes,
to
my
pay compensation. Now, my lord, before that.
And my lord, I am annexing the prior of that is last 2 pages, my lord, 21 and 22. They are agreed to do so, taking the money, my lord, file. Only for this reason, my lord, I filed this modification before your lordship.
Yes, Mr. Pan, what do you say?
No, lordship, kindly turn to page 6, paragraph 5 of the application.
Please, page 3, paragraph.
Page 6, paragraph 5.
Yes.
Paragraph 5 তে এতে আছে। Yes, জমা।
Yes.
But I could not follow the averment. I could not follow the averment.
But
Now-
you agree
now,
with this direct purchase policy?
Policy, my lord, only thing is this, my lord, this cannot be termed as compensation. What I am on before your lordship is this, and policy does not speak about the compensation. Policy speaks about the
My lord,
land value.
my lord, Ingreji
Mr. Pan, that is, the direction was to initiate a proceeding under 2013 Act.
My lord.
So now they have taken out an application. They want that fresh purchase policy. So that is subject to your agreement or not. So are you agreeable to that? You are agreeable.
Only
Yes,
thing
Mr.
is this, only to complete the entire process within 4 months.
Yes, ma'am.
Then Mr. They
Yes.
file an affidavit to that.
Yes.
My client, my lord, as because my lord.
I am telling you, don't take that.
Yes, my
back
lord.
on
Your
your
lordship.
shoulder.
Yes.
That
On
is
the
why I am
Yes.
asking you to file and let the client file the affidavit.
Yes, my lord. Yes.
Don't take it on your burden.
Yes, my lord.
Because someday someone can come and say, no, that was not my instruction.
My lord, I took the instruction. After that, I am.
Yes, I am recording your submission.
Yes,
So who shall file an affidavit that this will be
That is
completed?
the patient land acquisition officer. That is, he is the
That is,
authority.
the entire proceedings, including payment of compensation, will be
Within
done
4 months. Yes, my
within
lord.
4 months.
Yes, my lord.
Uh,
Talk to
Lord,
it.
subject to the correction of my learned senior friend. That is the collector who is the competent authority. This is the collector. Under the affidavit should be filed by the collector because
Let the
ultimately.
collector file the
Yes.
affidavit.
Collector
Let
has
the collector
complete.
file the affidavit.
My lord, collector, it is a difficult job to come before the Honorable High Court collector.
I leave it to you, Lord. I leave it to you. I will not bargain. I leave it to your lordship, my lord. Whatever they think they have to undertake before this court, that they will do this.
এটা item number
340
40
লিখে দিয়েছি
So by recording that, Mr. Pan, I am disposing of this application.
Yes, yes. Recording, because there is an undertaking at page. Your lordship can dispose of this matter on the
File Mr. De, how soon can you file that affidavit?
Yes.
My lord, minimum 10 days, my lord, I asked them to come and
Or my lord, can it be disposed of? Because in the form, if I am not wrong, Deputy Secretary, by a letter date, if your lordship, can it turn to page 11?
Yes.
Page 11.
Yes, Deputy Secretary has written to the Special Land Acquisition
Yes.
Officer.
Within 4 months, they have said that within 4 months, this is entire thing is to be completed.
for that reason, my lord, I have got the instruction for that reason, my lord.
Where it has been stated that within 4 months.
Yes. 4 months they have stated by way of an affidavit before this honorable court that
No, 4 months time has not been stated here.
Why?
yes.
Enough,
If your lordship kindly see
Hey, bhai.
direct page of policy and complete the yes paragraph 7, page 7.
Paragraph 7.
Page 7. And this is being affirmed by
yes, within 4 months.
Yes.
Yes, my lord.
Yes. The special
Then
land-
there is no necessity to.
Yes, yes. Special land acquisition himself has affirmed this affidavit. না এটা লিস্টেই নেই না এটা মেনশন করে
Content
তোমাকে
as
আনতে হবে
it is file is not here, I cannot pass.
That is not what
That will be listed, I will pass an order.
Similar, your lordship passed the order, and that order I've also filed on my lord modification. That matter may be come up in the list only for that.
May ask your learned junior to mention that. Yes, who is appearing in this matter?
I beg to appear for the
Yes,
PhD
Mr. Banerjee, you are mentioning matters and not appearing when the matters are called on.
I missed, my lord. Today, my lord, I missed. But I was, my lord,
So your choice, you are making a choice
No,
in
no.
which matter to be, you will appear, taking the advantage of the resolution.
No,
Some matters you are appearing, others you are not appearing.
my lord, not because of the resolution, my lord, I missed, my lord.
What means?
No, no, missed the,
I
my lord,
asked
missed
your
the thing.
senior to call you.
Yes, yes, my lord, Mr. Chatterjee informed me, my lord, I came, my lord, after. Then, my lord, your lordship had already taken, gone to the next matter, my lord.
Yes, yes. What is
For,
this
my lord,
application?
extension of interim order, my lord.
Extension of interim order.
Extension of interim order, my lord.
Yes.
Kindly take up my application, my lord.
What is the impugned order?
My lord, an application of the opposite party, my lord, that has been allowed.
What is the application of the opposite party which has
My
been
lord,
allowed?
under section 63, 65A and 65B of the Evidence Act, my lord.
Yes.
That has been allowed. I have been, my lord, directed.
When the interim order expired?
Expired sometime back, my lord.
Yes.
My lord, lastly, my lord, extended on 4th of October 24th, and it was till, my lord, the end of the month.
Very
of
short matter, your lordship can dispose it of kind.
Can one of 2025, this is an
My lord.
will appear. Yes. Call the next matter. Yes.
Restoration application.
Restoration application.
With section 5, delay of.
Section 5. What is the impugned order?
Only the dismiss for default. No impugned.
What is the impugned order?
Impugned order is not there.
What is the challenge in the civil division application?
I'm sorry, ma'am. But the civil division application, it is a change brief, madam. It is specifically preferred for expeditious disposal of the application, madam, pending before the learned trial.
Expeditious disposal of what proceeding?
It's a probate case. The subsequently, madam, the content of they preferred a revocation, and the revocation application, madam, section 5 is there.
This was dismissed at the motion stage.
Yes, madam. It's dismissed at the motion stage.
Asan. And one. This is an Subquota disposed of. CO can. Yes, next.
Supplementary. Supplementary.
Yes, yes, next. Appearing, yes.
Lord, my application, my lord, for restoration of the CO that I have filed.
What is the impugned order?
Lord, the impugned order is the order passed by the learned DRAT on 31st of January 2025.
Yes, what is the wrong in the impugned order?
Lord, the wrong in the impugned order was that, my lord, the learned DRAT has, my lord, held. If your lordship may kindly take my CO
What
once.
was the challenge before the DRT?
Lord, in the DRT, there was a surfacey application which was filed by the borrower. That surfacey application was allowed, my lord, and the sale was set aside. Lord, on that ground, my lord, we have proceeded before the DRAT. Lord, DRAT has, my lord, confirmed that, against which, my lord, we have filed. We are the bank, my lord. We have filed, my lord, a civil revisional application. My lord, on the first day, my lord, we could not, my lord, due to our non-appearance, my lord, it was dismissed for default. I will beseech your lordships to kindly, my lord, restore that application, my lord.
Yes, what is the wrong in the order? Nothing is wrong in the order.
Lord,
In the auction notice, the surface application was that was not indicated.
Lord, kindly, my lord, allows me, my lord, once, my lord, because, my lord, it's a...
Yes, please make submissions on the merits.
Lord,
Restoration is not a matter of right.
my lord. If your lordship may kindly, my lord, since, my lord, there was... if your lordship may kindly restore that, my lord, we'll make appropriate...
No, sir, no peaceful business. I can adjourn it. Restoration, main matter, you have to be ready. After taking up all the main matters in restoration. On the prayer of the learned advocate appearing for the petition.
Grateful, my lord.
Yes. Dismiss for default.
Vacating.
Vacating, Mr. Rai, who is for the...
Wait, 44. 45.
Who is in this matter? Sudeep De, Parthopratim Roy.
45 এটাই তো কি বলিস
Mr. Rai, that happens. So many matters.
It's not my fault, it's fault of my juniors. This I cannot take responsibility. I am here just entering, they say not this matter. But here I'm drawing lots of two places. Vacating, I'm only drawing lots of...
But Mr. Rai, the other side is not here.
That is why, my lord, why I'm visiting your lordship only kindly comes once. After that, I'm not asking for vacating. I want some 2021, 2001.
10th October 2000.
2000. Consent award was passed. Execution still, since then execution started, went up to Supreme Court. 2197, everything. Supreme Court dismissed, says immediately. That is the order, my lord.
What can I do now in their absence today? Can I take up?
Something. I know it is hard pressed, your lordship. I can pray with your lordship for fixing the...
Oh, wrong file has come. In that file, that is your file has come, but the matter is different. Eta ke ache? What is the item number?
We are in 45.
Who is in 344? Not today, next. 345. Dakun, 345.
345, I am pretty sure that it is that better, my lord.
345?
In the matter, we are the opposite party, interim order has been granted. I'm inviting the lordship to some precedence, some to that extent. 21 years, my lord, and some page 39, my lord will find some precedence so that I can communicate there, the matters called out.
Sir, Rai, that is why I fixed all these applications today. I have kept it today. What can be
That
done?
is why, my lord, I can say that it can be taken.
Let me see what can... Yes, call the next matter.
Item number 346.
346? Yes. You are for the petitioner?
I am for the petitioner.
Other side is here.
My application was rejected instead of writing extension, it should be reimposition. My extension application rejected on that ground.
But the other side, you have
Yes.
solved.
I'm sorry, revision service, but I cannot invite a lot. So, 26 is the date fixed, my lord.
What can be done, Mr. Rai?
So only for extension, let the matter be appearing under the heading extension of entry order. That prayer I can make before your lordship.
This is an application for extension of
Extension
entry
of
order.
entry order.
Mr. Rai, learned advocate, appears for the Call the next matter.
Didi, আপনি করতেন?
347.
Same, my lord.
Extension.
Extension.
Why did not text us for extension within the time, Mr. Rai?
Now can you consider the order? I will not argue a single word before your lordship. Kindly consider the order. Last order.
Last.
My rejecting my application for extension of interim order. It should be reimposition of interim order instead of the extension of interim order as you mentioned.
Pass over next.
My lord, same, my lord. Extension interim order, inform my lord. That is the prayer. Till today, my lord.
But সোমবার extension এ দিয়েছে।
Tuesday.
Why?
Where needs some personal difficulty. I might not be come on Monday. I might not be. That's why.
আচ্ছা করে দিন ওটা the learned advocate for the petitioner is present.
$348.
248. Sorry, 348. Who is appearing? Pass over next. 349. Pass over next.
Item number 350, lordship, praying for not today. And
Why? Madam, you have mentioned this yesterday. It was fixed at 3 p.m. Why?
not in this matter, lordship, and their clerk instructed me to.
Let me see. What is this matter? Din 350. It was called on at 3 p.m. also.
Mr. Anuruddha
was
Chatterjee was
mentioned.
appearing in this matter, lordship.
It has been fixed at 3 p.m.
Yes, lordship.
So it's double fixing. One is
Their
under
clerk
that heading and 3 p.m. This cannot be adjourned.
Their clerk instructed me to take the.
Din. This was called on at 3 p.m. also. None was there in 3 p.m. Ask him to come. Pass over. Yes, next. Ask him to come. Yes, next. After 352, it will be called on. Please ask him to come. 351. Not today, next.
In this matter, I am for the petitioner.
I beg to appear on behalf of the plaintiff petitioner before your lordship.
Yes, yes.
It was dismissed for default on 16th of June. I mentioned this matter because your lordship was kind enough to update the matter. I missed the list. Your lordship kindly continue in this regard.
You have so many juniors, none were present.
Your lordship kindly condone this time. Actually, bona fide mistake on behalf of the advocate on record as well as the concerned clerk, was kindly condone. Allow me to argue on the merit of the case.
What is the order impugned?
Your lordship, last page, your lordship kindly have a look through.
Yes.
Order dated, your lordship, 6th March 2025.
Yes.
On that time, the date was fixed for evidence. In the meantime, what has happened? This is there are 7 plaintiffs. Number 7 plaintiff died on 17th February 2024. But this was not brought to the notice of the learned advocate who was proceeding with this case. That is why an application under section 5 of the Limitation Act, along with an application for substitution and after sitting aside amendment, 2 applications has been filed. On 3rd March 2025, page 170. Page 170 starts from page 170 for substitution of the only daughter, married daughter. And in that effect, an application was filed on 6th March 2025. Learned judge held that.
Yes.
Held that as it gets present case, the suit involves multiple plaintiffs. Paragraph 5, your lordship, order sheet. In present case, the suit involves multiple plaintiffs and the cause of action is not shown to be exclusively personal to plaintiff number 7, Aloka Bose. The legal representative of the deceased plaintiff may be brought on record in accordance with Order 22, Rule 3, TPC, and the remaining plaintiffs still have a subsisting right to sue. Therefore, the suit does not abide as a whole. Without taking in the application for substitution, page starts from page 170. This order was passed below. Although 7 plaintiffs have self-same cause of action and self-same relief rate for. Plaintiff number 7 had died, leaving behind only married daughter. I have annexed here with the copy of the death certificate as well as the legal heir certificate.
For setting aside abatement along with section 5.
Yes, ma'am.
Page 170 starts below. Later on, you will also be find for application for setting aside abatement.
Can 1 of 2025 by recalling the order dated revision applications to dismiss for default to dismiss for default. First up, in view thereof, the order dated June 16, 2025 stands recalled. First up, the civil revision application is restored to its original file and number. Application number 1 of 2025 stands allowed. বলেছি তো? First up, paragraph CO তে order করুন. CO 1226 of 2025. This application under Article 227 of the Constitution of India is at the instance of the plaintiffs.
My lord,
is directed against an order being number 22 dated 6th of March 2025 passed by the Learned Civil Judge Junior Division Kharagpur District Paschim Medinipur entitled suit number 188 of 2022. First up, by the order impugned first up, the plaintiff number 7, namely Aloka Bose, expired on 17th of February 2024. First up, the petitioner herein took out an application under Order 22, Rule 9, and an application under Section 5 of the Limitation Act. File an application under Order 22, Rule 9 of the Code of Civil Procedure, praying for substitution of the heirs and legal representatives of the deceased plaintiff number 7 after setting aside abatement. First up, since the said application was filed beyond the prescribed period of limitation, an application under Section 5 of the Limitation Act was also filed along with such application. First up, by the order impugned, the learned trial judge recorded that the suit did not abate as a whole and the heirs may be brought on record in accordance with Order 22, Rule 3 of the Code of Civil Procedure. First up, paragraph petitioner is directed to serve a copy of this application upon the opposite parties by register speed post with acknowledgement due and file an affidavit of service on the next date. First up, there shall be an order of stay of all further proceedings in title suit number 188 of 2022 pending before the Learned Civil Judge Junior Division, Kharagpur District, Paschim Medinipur till the end of the month of December 2022 or 2025 or until further orders, whichever is earlier. List this matter under the heading motion in the monthly list of November 2025.
It should deeply appraised to Lordship. Grateful to your Lordship.
Yes, call the passed over matter. Item number 350. 350 টাকা 350 যেটা পাস ওভার করলাম।
There was another passed over item number 58 of today's list. This is an expeditious disposal application.
58?
Yes, your lordship.
58 টা আছে দেখুন তো। আচ্ছা দেখুন কোনটা পাচ্ছেন আগে, 350 টা পাচ্ছেন?
350?
Yes, 350 who is appearing? Yes, who is appearing in 350?
I'm being just told that Mr. Aniruddha Chatterjee is appearing and he's not there today, my lord.
Mr. Aniruddha Chatterjee is a senior advocate. He is being assisted by other advocates, a battery of juniors. Where is the learned advocate on record? Mr. Chatterjee is not the learned advocate on record. Where is the learned advocate on record?
I'm not aware about that, my lord.
Ask him. He is instructing. Who is the learned advocate on
They're
record?
not, my lord, they are not here, my lord. Nobody is here today.
I want to know the name. What is the name of the learned advocate on record?
Devokhinandan Maiti.
All right, not today. Yes.
Lord, I have, Lord, with your lordship's permission, my lord, may I just mention serial number 23. My lord, your lordships have called serial number 23. Mr.
Yes.
Krishnaraj Thakkar was leading us. My lord, he had gone for the funeral because of the Bal Library Club resolution.
Yes.
We could not appear today, my lord. I was humbly praying if the matter can be kept tomorrow, my lord. There's some
What
urgency.
has been done?
But it's been kept on the monthly list, my lord, because there is some urgency.
Monthly list? Who told you it has been kept in monthly list? Who told it has been kept in monthly list?
Lord, we have just come to learn, my lord. I may be incorrect, my lord. I'm just praying if
Item
this
number
matter.
23 টা কি অর্ডার হয়েছে? কবে থাকবে? Yes,
But
it
if
has
this,
been adjourned.
if this matter can appear tomorrow, my lord.
Not paid in the monthly list.
Lordship,
Lordship,
may I pray for an indulgence, my lord? My lord, I'm 360, item number 360 of today's list, my lord. It's a contempt application, my lord. My lord, the petitioner is a senior citizen, my lord. This is appearing for the first time. If your lordship will kindly give a direction for service. Your lordship.
360.
It's a contempt application, my lord.
360 ফাইলটা আছে কন্টেম্পটের।
Your lordship had passed an order, we had made our representation, but your lordship's order was not complied with. Reminders have been given, my lord.
Lordship,
But
item number
tomorrow, my lord, let the matter appear tomorrow, my lord.
I do not know, but let me see thereafter.
It's appearing for the first time, there has to be a direction for service, my lord. That is why.
No, that one matter cannot be taken up. I will fix a date for this group. Because today, this could not be taken up.
Because,
but
my lord, this petitioner is, my lord, he's a
yes,
senior
I will
citizen
consider that.
suffering.
Spell it up. Koto item number? What is your item number?
58, your lordship.
58.
It's an expeditious disposal application filed for expedition of the divorce proceeding filed by the husband, your lordship. The next last date was on 21/5/2025 and the next
Your
date,
copy.
your lordship.
Who are you?
I'm the petitioner husband, your lordship. I had filed a divorce proceeding.
Yes,
The year
wife has appeared.
Yes, your lordship, but till now no written statement has been filed by the wife. It's
But
been
why
a
it is
3
fixed
years.
for service returns?
Your lordship, there was a report, the matter was sent for mediation, your lordship.
What
Thereafter,
happened to the mediation?
mediation report has been called for more than a year now. Till now, it has not reported.
Unless the
and it has failed.
mediation report comes,
It has failed, your lordship, but the report has
it has
not yet-
failed.
Yes, your lordship.
So date has been fixed for framing of issues.
Yes, your lordship, after 6 months in month of November, your lordship.
This application under article which you filed about.
Yes. My lord, serial number 23, my lord, may it appear in the list tomorrow, my lord. There is some urgency which is there. I'm otherwise ready to move the matter also.
Sir, it has been made only adjourned for this day.
Okay, wait.
My lord, item 210, my lord, is the expeditious style, my lord.
File has to be found out. Yes, sir.
At least upgradation there, my lord.